All right, it's 11 o'clock. This is the subcommittee meeting of the criminal laws, constitutional laws, subcommittee of the Judiciary Committee of the House. We've got two bills on the agenda, House 3101 and House 3473. Appreciate y'all all being here. It's a big turnout. I believe Representative Chumley is here and asked to be allowed to speak first on his bill. Representative Chumley. Well, I understand the enthusiasm from Mr. Chumley, and I'm glad we got that out of our system. The way these hearings work is we would ask you guys to not comment, hiss, boo, cheer, yell amen, or anything else while the speakers are speaking. It'll delay the hearing. It's hard for us to follow what's going on. And this is a serious matter. And we expect everybody in the audience to treat it that way and treat this committee and the process with some respect. So I'm glad that everybody got an opportunity to let us know how appreciative they are of Representative Chumley. But I would ask you to compose yourselves in the seriousness of the matter and to keep your, at least the outburst to a minimum. We do have some sergeant-at-arms that can help remind you if anybody can't remember that. Representative Chumley.
Thank you, Mr. Chairman. First of all, I'd like to thank you and the committee for allowing us this hearing on the bill. We appreciate it. Thank you so much. And I certainly would, you don't have to applaud, but I want to tell all of you, thank you so much. I appreciate you being here. It's a sacrifice for you to be here. And I understand that, and I just appreciate you so much. Thank you very much. So thanks to everybody. Okay, thank you all a lot. Mr. Chairman, this bill H3101 is a bill to pretty much stop Obamacare in the state of South Carolina. And what we want to do with this bill, first of all, what this bill is not about hate or of anybody or any administration or anything like this. This is a bill about love, and it's a bill about love of freedom, love of liberty, love of our way of life. And it's also, this bill is particularly about my children and my grandchildren and all these people's children and grandchildren that's going to be coming out. They deserve to have the opportunity to live in a country that I grew up in. And what I firmly believe is this bill is going to impact that dramatically. Just a quick history. We've got some good speakers following me, and what I'll do is I'll tell you just quickly a couple of brief statement about this, and then I'll leave it to the speakers. And they should answer just about any question I think you'll have. And if they don't, at the end, if you want me to come back, I'll be glad to answer any questions then. But what this is an issue where we put together a committee of people, volunteers, medical doctors, attorneys, small business owners, pastors. Back in September, we started meeting to look at this. My constituents wanted us to do something about stopping this bill. And I totally agreed with them, and I wanted to do something about it. So we put people together. We took a look at it. We did our homework, we studied this, we had constitutional people, scholars that we talked with on the phone. I'm working with 7 other states on this now, 7 other legislatures and senates of other states that are in various parts of this and various impacts of this. So I have talked with all of them. We feel like it's the thing to do. We feel like we're doing something that's legally, morally, ethically correct. We believe we're okay on that. If we didn't, I wouldn't be doing this. And I believe passionately about what we're doing. So this bill is about stopping Obamacare in the state of South Carolina, and it's for the good of the people. There's issues in here that clearly seem unconstitutional, and there's some that are just plain wrong. Now, we can't do too much about the wrong thing of our feelings and all, but we could do a lot about it being unconstitutional. 10th Amendment Center has worked with us a little bit. There's several other people who have looked at this, and I believe in what they're doing. And so, with that being said, that's what this is about. And the people, my constituents, I am duty bound as a legislator to do what I feel like my constituents want within the law. And it's an honor and a privilege to do this, and I don't take it lightly. It's a pleasure to do it. So, but other than that, it's our duty. And I think as a state legislature, that we have a chance to stop this now, and I think we'll have other states to follow us. So I'll yield the rest of my time to anybody else that wants to speak like this, and if you need me to come back, I'll be more than happy to.
Thank you, Representative Chumley. Representative Smith.
Yeah, excuse me, thank you, Mr. Chairman. Representative Chumley, I have a few questions for you. I have some questions about your bill.
Representative Chumley, you want to take questions now?
I will at the end. I think most of the questions will be answered now. With these
All right, Representative
I'd
Chumley.
like to address them to you, though, so you'll still be here later.
Yes, sir. I certainly will. I'm not going anywhere.
All right, the next, we have Professor Crocker. Professor Crocker, thank you for being here. Come up and introduce yourself, tell us who you are.
Hi, I'm Professor Thomas Crocker. I teach at the University of South Carolina School of Law. I teach constitutional law.
Okay, thank you for being here.
Thank you for having me. Would you like me to just?
I would, just.
All right, so let me thank you, Mr. Chairman, for having me to speak here, and thanks to the rest of the committee for having me to speak here. Sometimes lawyers and constitutional lawyers are no different, speak with 2 hands. On the one hand, on the other hand, there always seems to be 2 answers to a constitutional law question. But this is one of those rare occasions in which there's a one-hand answer. This is one of those clear occasions in which the proposed bill is unconstitutional. There's one and only one right answer to the question of whether it is in fact constitutional. The state of South Carolina lacks the power to nullify a duly enacted bill by Congress. So let me provide just a little bit of legal background. The Patient Protection and Affordable Care Act was passed by the U.S. House of Representatives by a vote of 219 to 212, and in the U.S. Senate by a vote of 60 to 39. It was then presented to the President, who then duly signed the bill into law, in accordance with the bicameralism and presentment clause of Article 1, Section 6, Paragraph 2 of the U.S. Constitution. On completion of this procedure, the Affordable Care Act became the supreme law of the land, pursuant to the U.S. Constitution's Article 6, which provides, "This Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land." The Affordable Care Act was challenged in federal court under various theories that the act was beyond the power of the Congress to enact. On June 28, 2012, the U.S. Supreme Court ruled on those arguments in a case called National Federation of Independent Businesses versus Sebelius, holding that the basic provisions of the act were a constitution under Congress's Article 1 power to levy taxes. Since the 1803 ruling in Marbury versus Madison, it has been well established that under our Constitution, the Supreme Court has the ultimate power to decide matters of statutory and constitutional interpretation. And if there were any doubt about the matter, in a case in 1958 where the governor of Arkansas had attempted to defy a desegregation order, the Supreme Court held that Marbury, quote, declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution, end quote. To underscore its claim in Cooper v. Aaron, Each of the 9 justices individually signed the opinion, the only time the court has ever done that. So, underscoring the idea that the federal judiciary is supreme in the exposition of law of the Constitution. So to recap where we are regarding the Affordable Care Act, we have a law duly passed and signed under Article 1's bicameralism and presentment clause, a final authoritative interpretation rendered by the U.S. Supreme Court, holding that the act was within the power of Congress, and we have Article 6's declaration that federal law shall be supreme in the law, in the land. With that, South Carolina lacks any power to render the Affordable Care Act inoperative in the state of South Carolina. As a general matter, we can turn to the Supreme Court's 1819 opinion in McCullough v. Maryland, where Chief Justice John Marshall made clear, quote, "Whatever the United States have a right to do, the individual states have no right to undo." This is the baseline, uncontestable conclusion of constitutional law. South Carolina lacks the power to nullify a federal law. Article 6 of the U.S. Constitution makes clear, again, that this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. This is the supremacy clause. Now, if I'd like to go through a few of the provisions of the Act to also suggest a few additional issues of constitutional law that the Act runs up against. First, in the preamble, there are 2 problems in the preamble. One is a little more philosophical problem with the preamble's presentation of the power of the states vis-a-vis the federal power. In the 1819 Supreme Court case to which I've already referred, McCullough v. Maryland, it has been the law of the United States that the power of the United States government derives from the people, not from the states, and not from the people of the several states. In an 1816 case, Martin v. Hunter's lessee, again, Chief Justice John Marshall writes, "The Constitution of the United States was ordained and established not by the states in their sovereign capacities, but emphatically, as the preamble of the Constitution declares, by the people of the United States." There can be no doubt that it was confident to the people to invest the general government with all powers which they may deem proper and necessary, and give them a paramount and supreme authority. This is what we did as a country. We gave the federal government supreme authority to act within its empowered domains. So, second, a state has no power to declare a holding of the U.S. Supreme Court unconstitutional as the preamble suggests that it might. As I think the bill implicitly recognizes, states do have certain police powers reserved to them under the 10th Amendment to legislate locally regarding the health and welfare of its citizens. That generalized police power does not include the power to contest, through contrary legislation, the constitutional decisions rendered by the Supreme Court. As to the operative sections of the bill, which purport to make it a crime for federal officials or state officials, a felony and a misdemeanor respectively, to attempt to enforce the provisions of the Affordable Care Act within the state, these operative provisions are unconstitutional in light of the theory as I've already outlined it. As I understand this concept of nullification, it is by definition a violation of the Supremacy Clause. It occurs when a state legislative body attempts to prevent federal officials from implementing federal law, or state legislation purports to render ineffective, inoperable, criminal, or in any other way null federal laws within the state. H3101 purports to make it a felony for federal officials to carry out federal law, and as a consequence, the state of South Carolina cannot legally do this. It's not within its power. To do so would undo the very Constitution we support and uphold and pledge our allegiance to. Again, let me quote from Chief Justice John Marshall from an 1809 case. And if you notice, I'm referring to a lot of Chief Justice John Marshall cases from the early 19th century, suggesting how long and how deeply entrenched the tradition And the law on these matters is, it's not a recent matter, it's not something that's arisen in the last 20 or 30 years, it's something that goes back to these principles go back to the very founding of our country. So in the 1809 case, United States v. Peters, Chief Justice Marshall writes, "The legislatures of the several states may, at will, annul the judgments of the courts of the United States and destroy the rights acquired under those judgments. The Constitution itself becomes a solemn mockery, and the nation is deprived of the means of enforcing its laws by the instrumentality of its own tribunals. So fatal a result must be deprecated by all, and the people of," and let me add, South Carolina, the case was about Pennsylvania, but the people of South Carolina, not less than the citizens of every other state, must feel a deep interest in resisting principles so destructive of the Union and averting consequences so fatal to themselves. This isn't a debatable point. There is a definite and right answer here. The state of South Carolina has no power to nullify the Affordable Care Act. Let me end with one more consideration. Article 6, which also contains the Supremacy Clause, also requires, has what we call the Oath Clause. It requires that, quote, "the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. This Constitution includes the provisions that federal law is supreme over state law." Thus, the members of the legislature of the state of South Carolina have taken this oath of office, and this oath of office binds them in their duty to uphold the Supremacy Clause of the federal Constitution, which says that duly enacted federal law is supreme within this nation. So with that, that's my prepared remarks. I'm happy to answer questions.
Professor Crocker, the case Cooper versus Aaron, can you tell us what the case was about? What was the issue? What were they talking about?
Federal court had ordered the state of Arkansas to desegregate. Governor Valdes had attempted to defy that order and to not allow African-American students to go to school with white students. And in response to that, the case was heard by the Supreme Court, who made it unmistakably clear. The Supreme Court doesn't have its own police force. It has capital protection, but it has no police force. They can't enforce it. The most they can do is essentially jump up and down and say, each one of us signs this individually. This is how law works in our system. And the governor, with some more pressure, backs down.
Have there been other attempts in the country at nullification on other laws, segregation other than Arkansas or other places where legislatures have basically nullified federal law and then called on that?
In the early 1830s, the state of South Carolina was involved in what is known as the nullification crisis, where the state of South Carolina attempted to nullify a federal tariff bill. President Andrew Jackson spoke very passionately and has a very good presentation of why this is unconstitutional. But over negotiations between the administration of President Jackson and the state government of South Carolina, a compromise was reached and no further sort of controversy was averted in the short term. So we didn't reach a constitutional case out of that. But other than that, I don't know of any other occasion where nullification has been contested other than those that I have mentioned, Oldie, Maryland, and earlier with the state of Maryland attempted to tax a federal bank unconstitutionally. I don't know of another nullification.
All right. Any other members? Everybody does. Chairman Lane.
Professor Crocker, in your study of the history of nullification, have you ever seen a bill or resolution or proposal that proposed to arrest federal officials, agents,
No.
judges, and place them in jail for a felony, or arrest state officials and place them in jail for a misdemeanor for enforcement of a lawfully passed federal law that was passed by both houses of Congress, signed by the President, and found, at least in main part, constitutional by the United States Supreme Court?
No, sir. This is unprecedented.
Thank you, sir.
Representative Post.
Professor, I'm going to ask it a little different way, because I follow, like, there's the 10th Amendment website, and there's a lot of proposals I see from a lot of different places. And as I read behind them, oftentimes it'll say, for example, Montana is going to arrest federal officials for doing blank, weapons, Second Amendment issues or something. And I know Representative Delaney asked, have you ever seen, there are proposals, clearly there are numerous similar proposals out there that indicate that they would charge the feds for enforcing federal law. That much is clear, is that correct?
I understand this is a contemporary issue where there's
Okay,
lots of.
and so my question, it kind of piggybacks on what he said. Do you know of any indication in history, and I'm an old prosecutor, so that's what I'm trying to, when I first saw it, my concern is we're going to arrest the federal agents for doing their job. Have you seen any indication that anybody, a federal agent, for example, of course we cover state agents here too, has ever been arrested for enforcing a duly enacted federal law?
Not that I'm aware of. That doesn't mean that it hasn't been attempted, but not that I'm aware of. But even if it had been attempted, it's clearly illegal. That's going to always be the baseline. The state agent doesn't have the authority, unless the federal agent has committed a state crime, so possession of drugs or some other duly criminal act that the state has authority to criminalize.
But certainly not for doing their job.
Not for doing their job.
The second question I would have, and I've talked to many friends about this, the distinction of, for example, California, Colorado, wherever, and using the marijuana laws, for example. It's my understanding that in that circumstance, the states have basically said, we're not going to enforce marijuana laws anymore. But they have not said we will arrest, for example, if the DEA came and did enforce marijuana, they're not arresting the DEA for enforcing those laws. Is that accurate?
That is accurate. And if you'd like me to elaborate, that's a very good example, because this is one of the confusing, sometimes it can confuse people. And so the state of Colorado, once upon a time, made it illegal to possess marijuana. It's illegal under federal law to possess marijuana. In such cases, states and federal government have concurrent jurisdiction. You can both make something illegal. But if Colorado decides not to make it illegal anymore, what that means is that state officers and state officials are no longer going to seek prosecutions in state courts, but the federal government is free to seek federal prosecutions. So the act, the individual who possesses it, is still breaking a federal law, even if they're not breaking a Colorado law. And an individual arrested under a federal crime by a federal agent has no defense that this is legal under state law. And the state would have no power or interest in attempting to prevent the federal agent from enforcing federal law. So that's a concurrent jurisdiction problem. Here with this bill, it's not a concurrent jurisdiction problem.
Representative Smith.
Thank you, Mr. Chairman. Professor, appreciate your testimony before us today, and I wanted to just make sure I understood a couple things here. To recap, you cited the supremacy clause first, and that this was duly passed and signed into law. Then on top of that, it was tested before our nation's highest court, to which there it was found constitutional. And then you referenced, I thought very importantly, our oath of office, the oath of office of every member of this subcommittee and every member of the General Assembly. And as I understood it, you don't need to point to any specific case here, but for a state legislator to advocate nullification of a federal law is to advocate violating the legislator's oath of office, our own oath of office, if we were to advocate for the passage of this bill. Would you please elaborate on that?
Well, it's because the oath of office requires you to uphold and support the Constitution. I've laid out what the Constitution requires, and so to pass or to vote in favor of, to pass a act that violates that Constitution is to put you in this conundrum. You are passing something that violates your own obligation to uphold the Constitution.
And no matter how passionate one might feel about this, whether they think they didn't like the Affordable Care Act or they don't believe it should be the law of the land, the fact is, it is the law of the land. And
Yes,
that
sir.
has been upheld by the highest court in the land. And we have no authority, as I understand your testimony, at all, to deny that fact.
Yes, sir.
We're-
You have no authority.
Powerless to do it.
Yes, sir.
But advocating to do that would in fact, no matter how passionate we might feel about it, would be a violation of what is a very sober and responsible oath that we took to make sure, regardless of our feelings about it, that we uphold the Constitution, which is the basis and foundation of our nation. Is that correct?
Yes, sir.
Thank you.
Representative McLeod.
Thank you, Mr. Chairman. Professor, what you really told us is that South Carolina has no power to nullify a federal law.
Yes, sir.
Well, let's talk about what are the constitutional ways that we can change the law. So, one is you can change political, is it correct to say we can change political leadership?
Yes, sir.
Is it correct to say we can challenge the law in the federal court, as was done in this case?
Yes, sir.
Is it correct to say we can change or repeal the existing federal law?
No, sir.
We, not the state, but I mean the citizens of our nation.
Oh, yes, sir. Yes.
And all Congress could defund the federal law, so it would be properly implemented.
Yes, sir.
And finally, we could in fact change the Constitution to come up with numerous ways.
Yes, sir.
So those are lawful ways that the people of America, or the people of any state, can utilize within the Constitution to change a federal statute.
Well said. Yes, sir.
All right, thank you so much.
Chairman Delaney.
Professor Crocker, even if we could define Obamacare, because you can't define it right, they're still writing, I mean, it's like a 2,600-page skeleton bill with more than 30,000 pages of regulations. I'm told there are more to come. And we won't really know what it is until January of 2014. We know what parts of it are, but we don't know the whole thing. Even if you could define, you know, the tariff of 1832, you could define. The Alien Sedition Act, of the Kentucky, subject of the Kentucky Resolution, Jefferson's Road, you could define. You really can't define Obamacare. And certainly all of it is not going to be unconstitutional because it's going to be the whole federal medical delivery process. It's going to be Medicare. It's going to be Medicaid. It's going to be TRICARE. It's going to be veterans benefits. It's going to be insurance that are part of those exchanges. It's going to be the whole thing and even more. It'll be taxes. It's just a monstrous thing that you can't define like you could the tariff, like you could the Alien Sedition Act, like you could gun laws, or things of that nature. But say we could nullify, we could grasp our hands around it and say, this is what it is, and we're nullifying it. Would that be an act of aggression against the United States government? Or a threat of an act of aggression?
It would be an illegal act.
I don't even know.
And I just want to follow up on that. Has there been instances where the federal government has intervened with force when folks have refused, other than
I think there was a big war about
Other
this.
than that one.
And the South lost that war.
Since that point into the modern age, were there any of the nullification cases later in our history where the federal government was forced to have or used force to enforce the federal laws?
Yes, the federal government has had to use it in the desegregation context. So in the state of Mississippi, troops were used in desegregating the University of Mississippi, I believe. The governor of Galvez, that's the subject of Cooper v. Aaron, the governor of Arkansas. Federal troops were called out in Little Rock for federally authorized National Guard. And so there have been attempts to defy court orders or to defy federal law that have required a more forceful stance by agents operating on behalf of federal law to say, you're acting illegally, this is what the law is.
Any other questions for Representative Patton?
I want to follow through because, again, the prosecutor being on the sticking point about arrest. So let's say we pass it and we arrest an IRS agent, because everybody hates them. So we arrest an IRS guy, right? Okay, arguably, then the feds get a little uptight, maybe they send some help to spring him from York County Jail or whatever, right? Okay, even forgetting the physical conflict of it, we've now arrested an IRS. Would you anticipate it would then end up in the courts if we had arrested an IRS agent and then, say, convicted him of our felony? Would it end up in the courts? Would you anticipate?
If I were a Department of Justice person, I would seek an injunction as quickly as possible from a federal judge.
Okay, and then, of course, when you did that up in York County, we could appeal that on up the line, right?
Yes.
Okay, and where, if we kept appealing it and went to war with you, hired a bunch of lawyers, where, not real war, not Fort Sumter war, okay. If we hire a bunch of lawyers and we end up at the U.S. Supreme Court, based on everything you read, do you have any feel, in case I missed the first 40 minutes of what you had to say, if you have any feel, if we did all of that and went to Supreme Court, which side they would land on, whether it be South Carolina or the United States?
There's one and only one right answer, the United States. And it's likely your state judges would tell you that before it gets any further anyway.
Thank you, sir.
Any other questions? Professor Crocker, I appreciate you coming and giving us a little background on nullification.
Thank you very much.
Chairman Delaney, you have a second bill on the agenda. We make sure it's talking about both at the same time, I think. So as we hear from speakers, we'll hear, they'll have an opportunity to talk about Representative Chumley's bill and your bill. Representative Delaney.
And I'll explain my bill. You know, when you're talking about nullification, you're talking about resistance. And there's a right way to resist things, and there's a wrong way to resist things. There's a way to resist the federal laws that you disagree with under the law. There's a practical argument, and then there's an academic argument. And we may agree on the academic argument, but the practical argument is Obamacare has the full force and support of the United States federal government with all that comes with that, U.S. Army included. And that's just a matter of fact. There's a couple of principles here. Number one, you have to define what you're resisting. And as I've said, you can't define Obamacare right now. So you can't nullify something you can't define. We can define parts of it, and I'll talk about that in a minute. The other thing is, you can have all the 10th Amendment arguments you want, and I'll probably agree with you on all of them. It's just like, I think the southern states were within their right to secede, although it wasn't in the Constitution. I don't think it needed to be in the Constitution. I think everyone who joined up with the compact had a right to leave the compact. However, as we learned it out in the courthouse, a state only can exercise all the sovereignty. Number one, it can afford, and number two, it can defend. And you know, we have the 3rd Army located here at Shaw Air Force Base, just 30 miles down the road. You know, so if we commit some act of aggression against a federal judge or a federal employee, you know, they can handle that situation. What do we have to come against that? And affording it. What if we were able to nullify Obamacare and the president declares us in a state of rebellion? You think you're going to get your Social Security checks? You think you're going to get your Medicare coverage? You think you're going to get anything out of the federal government? So can we afford to nullify, as the professor said, commit this illegal act, which I submit to you is an act of a threat of aggression against the United States? And if we did go out and arrest some federal judge who had joined us and told us to pay the other side's attorney's fees, with the myriad of lawsuits that would occur, even if we were able to do this, you know, where does that get us? So I choose to resist within the law. I choose to do things that we can do, that we know we can do. You know, constitutional resistance, where we tell the federal government we disagree with your laws, and we're going to have our own laws, and but we're not telling you you can't enforce yours, and we're not telling you we're going to arrest your judges and arrest your bureaucrats, as one person told me. We're not going to tell them that. We're just not going to assist you. And I've seen a lot of the social blogs talking about the real ID. I think that came about under the Bush administration where they wanted everybody to have a national ID, and the states didn't cooperate. We didn't tell them they couldn't do it. We just told them we weren't going to cooperate. And as a result of that, it collapsed. And we don't have real ID. Just like the marijuana laws were brought up. You know, states out west have told the federal government, we want our people to be able to smoke marijuana if they want to smoke marijuana, so we legalize it. They didn't tell the federal government, you can't enforce your laws. They said, we're not going to assist you. And we're not going to prosecute anybody. Sanctuary cities. The sanctuary cities with immigration. State and local governments say, we like illegal aliens. We're going to protect them. Federal government, you want to arrest them? That's your business, but we're not going to help you. That's the way you do this. And even the president himself does some of this. You know, he ignores the Defense of Marriage Act. You know, he ignores our own immigration laws. But I choose to go about this the constitutional way. And H3101 has 3 provisions. And if we find out ways that we can throw a monkey wrench into the implementation or slow it down of Obamacare, we can do that as we go along. But I choose to resist Obamacare the legal way, the constitutional way. I plan to uphold my oath to the Constitution. And the first way is we exploit the inherent weakness of the Obamacare law in regard to state health exchanges and federal health exchanges. That's all about expanding Medicaid. And what the Cato Institute has come up with is that within the plain meaning of the law, only the state exchanges, and if you don't have a state exchange, our governor has said we're not going to, right now the thinking is that you don't have to opt out of Obamacare, you have to opt in. And our governor has said that we're not going to opt into Obamacare. And we passed a bill earlier this year in the House. It's going to the Senate, but it had a problem with it. It only involved state government. This bill involves not only state government, but quasi-governments and local governments. It involves all political subdivisions. It bans the state government, the political subdivisions, the counties, the cities, the school boards, eleemosynary hospitals that are political subdivisions, gas authorities, whoever, from participating in a state health exchange, which will expand Medicaid. And why is that important? It's because the Cato Institute has found out, and the Attorney General of Oklahoma is suing on this very issue right now, and it will eventually wind up before the United States Supreme Court, that because of the plain language of Obamacare, the states were encouraged to run state health insurance exchanges, where the state runs it, you come to the state exchange to get your approved medical coverage. And it was only the states that were given the authority to give the insurance companies subsidies, to give tax credits, and so forth. And as a result of that, it is only the states that can levy the John Roberts tax penalty on employers who have 50 or more employees. So if you are a small business person and you have a corporation that has 50 or more employees and you did not participate with Obamacare, you didn't provide the coverage because it was against your conscience to provide coverage that involved abortion-inducing drugs, then you would be shielded in a state like South Carolina and 25 other states who have chosen not to abide by the federal government's wishes and institute these state-run health care exchanges. Because if you don't, then the federal government comes in and runs one, and under the plain language of the law, the federal government does not have the authority to give the insurance companies the subsidies, does not have the authority to give the tax credits, does not have the authority to levy the John Roberts tax on that employer who violates the employer mandate. That's the first provision of this bill. The second provision deals with, and also I would like to tell you that right now 25 states have said that they are not going to provide a state exchange. That's 45% of the population of the United States. There are another 8 states that are seriously considering following suit. If they do that, that'll be 75% of the population of the United States will not be participating in Obamacare. The next provision in this bill, which I haven't got a physical impact statement, Mr. Kleck tells us that if Obamacare the uninsured in this state right now are about 500,000 people. And out of that 500,000 people, I don't know how many file an income tax. And I don't know how many file a tax. I imagine there are some people who are self-employed and have to get their own insurance. There are some people that are wealthy and just pay their own bills, and there are other people that are young who don't want to undergo the expense of providing health insurance and that sort of thing. And I don't know how many out of that 500,000 actually file an income tax and pay income taxes to the state of South Carolina. I'm sure it's not anywhere close to 500,000. But this bill, in order to encourage them to resist, all right, the state is resisting. We're encouraging employers to come here and be shielded, talking about economic development, to come here and be shielded from those John Roberts employer taxes, from the employer mandate. We're telling other people with the individual mandate, if the federal government taxes you with John Roberts tax, because they've already got their money, they already have their income taxes deducted and sent to the federal government, they already have that. And they're withholding their refunds. That's how they're going to enforce this individual mandate, John Roberts tax. Okay, so we're going to give them, in order to encourage them to resist, we're going to give them a tax credit to the extent they owe the state of South Carolina income taxes. We're going to give them a tax credit to the amount they have to pay the federal government in order to resist. The more people that resist, if other states follow suit, Obamacare will collapse under its own weight. The third provision in the bill deals with the Attorney General. And it allows the Attorney General, whenever he has reasonable cause to believe that a person or a business is being harmed by the implementation of the Patient Protection Affordable Care Act, Obamacare, and that would be in the public's best, or would be in the public interest that he bring an action against that person or entity, that insurance company that was participating in an exchange, or whatever panel that denied you coverage. But if he thinks that it's in the state's interest to protect that person, he can bring a restraining order, a temporary restraining order, a temporary injunction, and a permanent injunction to stop that practice. And what I envision that to be is when people are denied coverage, that you're denied a hip replacement because you're too old, or you're denied a transplant. You petition the Attorney General, and he could bring such an action. But that's just the start. And there may be better ideas than that. And as we go along, that's the way I anticipate resisting Obamacare. The legal way. The undeniably, the constitutional way. But that's what this bill is about. And like I said, if other people have ideas to lawfully resist, I'd be glad to hear from them.
Representative Quinn.
I haven't spoken with Mr. Chumley about this bill, and he went to great lengths to get an expert from his perspective. I think his name is Mr. Livingston. And as I understand it, he came from out of state and was very late getting here, so he's last on the list, and I'd hate to not give him the opportunity to be heard. Is it possible to move him up on the list in the agenda and go ahead and
I think that would probably be appropriate. And I'll tell you, he's not last on the list, he's about halfway. So we'll,
I just said Mr. Ryan time.
It asked me to make sure he got to speak since he wasn't. Dr. Livingston? Thank you for being here.
Thank you. John Livingston, recently retired professor of philosophy at Emory University, where I taught, among other things, philosophy of the law and constitutional law. Americans have never really agreed on what the Constitution is. And they don't agree today. I have friends, professors of law in various law schools, who will say the Constitution is dead. And thinking of it in one way, others will say it's very much alive. What I'm going to do, I'm not going to comment on the bill, I haven't actually read it, but I would like to say some general things about the Constitution, which might put the topic of nullification in a proper light. State nullification is not a violation of the Supremacy Clause of the Constitution. That clause says that laws made by the United States, quote, in pursuance of the Constitution, are the supreme law of the land. But that also means that acts not in pursuance of the Constitution are not laws at all. But who is to decide whether an act of the central government is or is not in pursuance of the Constitution? Now, some would say, indeed many would say, the Supreme Court. The court may indeed express an opinion, but it cannot have the final say, even if that say is consistent for 100 years. That can only be vested in the supreme authority that ratified the Constitution and gave it the force of law. The Supreme Court does not give the Constitution the force of law. That was whoever ratified it. And that was the people of the several states. Now, what did the states ratify? They ratified a compact between the states to create a central government to which were delegated only enumerated powers, leaving all other powers to the states. Article 7 leaves no doubt that the Constitution is a compact between the states, for it says the compact will hold, quote, between the states so ratifying the same, end quote. The powers delegated by the compact to the central government, as Madison said, are, quote, few and, quote, well-defined. The powers reserved to the states are indefinite in number and undefined. Who is to say what the undefined and unenumerated powers of the states are? The central government cannot have the final say on that because it is a creature of the constitutional compact between these political societies. The creature cannot tell the creator what its limits are. Only the states themselves have the final say over what their undefined and unenumerated powers are. And Madison said that if the central government should intrude into the states' reserved powers, the states would have a, quote, duty to, quote, interpose. He didn't use the term nullification, he used interposition, but the logic is similar. To protect their citizens from harm. Consequently, state nullification is not an act, in this view, whereby a state refuses to comply with a federal law that it doesn't like. Nullification is a claim that the supposed law is not a law at all, because it is unconstitutional. To deny state nullification absolutely is to say the central government can define the limits of its own power, which makes our liberties a gift to us from the central government. That is what one is logically committed to who says that the Supreme Court has the final say over what the reserved powers of the states are. But who honestly believes that? The Constitution does not even remotely give the Supreme Court that power. The Supreme Court has asserted it, but the Constitution is another thing. And if an amendment to the Constitution, let's imagine, were sent to the states today for ratification, stating that the Supreme Court has the final say over what the Constitution means, I think there's no chance that it would be ratified by 3/4 of the states. The people would not hand over the power to decide their fundamental liberties to 9 unelected, politically well-connected lawyers.
Amen.
The founders knew the central government would inevitably intrude into the reserved rights of the people. They sought to prevent this with a system of checks and balances. We're familiar with these. The president can nullify a bill of Congress, but Congress by 2/3 vote can nullify that act. The Supreme Court can nullify an act of Congress, or if the president is unconstitutional. Congress can nullify the powers of the court, restricting its appellate jurisdiction by impeachment, and so on with other nullifications. Let's call these horizontal nullifications, operating within the departments of the central government. But what if instead of checking each other, these departments began cooperating with each other to usurp power from the states to enhance central power and benefit whatever the ruling class might be? To check this usurpation, the horizontal checks are worthless. So the founders wisely recognized the need for a vertical check on central power arising from the people of the several states as sovereign parties to the constitutional compact. That vertical check is known as state interposition or nullification. Those are not exactly the same. Jefferson considered this vertical check to be the most important of all. He said the states are the best guardians of our liberties. And it has been used throughout American history at various times to protect the liberties of the people. New England states nullified the embargoes of Jefferson and Madison, 1808-1809. They nullified the War of 1812. They nullified the draft that was part of it and didn't participate in the war. Later northern states nullified the fugitive slave laws. Orders of the Supreme Court were nullified by Wisconsin in 1859 and earlier, and other cases. We enjoy ample forms of constitutional nullification, both horizontal and vertical, to protect our liberties. But that does not mean they will be exercised. For instance, by a simple majority, Congress could, under Article 3, nullify, in effect, the Supreme Court's control over school prayer, abortion, law enforcement, gun control, and 100 other things by removing those topics from the court's appellate jurisdiction. But it has refused to exercise that power. We might wonder why. The House, by a simple majority, could nullify Obamacare tomorrow by simply refusing to fund it. But it is not likely to do so. Instead, the House cooperates in the expansion of federal power. And so it goes. The states, as sovereign parties to the Constitutional Compact, have the authority to interpose to protect their citizens from unconstitutional acts of the central government. If you think Obamacare is bad, wait until you see what is likely to come down the road in the future. Now is a historic moment for the states to step forward and erect what Madison called a shield to protect their citizens from this latest of many intrusions into their reserved powers. Thank you.
Ladies and gentlemen, I know y'all are passionate about this, and Professor Livingston has a very nice speaking voice. I enjoy listening to you. But I do want y'all to refrain from any outbursts. Professor, will you take any questions from the committee?
Yes.
Chairman Delaney. You don't have, I'm sorry. Professor, or Representative McLeod.
I didn't hear what law school you were.
Sorry?
What law school are you a professor at?
I'm not a law, I teach philosophy. Philosophy policy law at Emory University.
Thank you so much.
Emory, yes, in Atlanta.
Representative Smith.
Thank you, Mr. Chairman. Professor, so you traveled from Atlanta, obviously, from Emory to be with us today.
Well, I just retired. I'm a recovering academic. I live in McClellanville on the coast near Charlotte.
Okay, so you're in South Carolina?
Yes, sir.
Okay. But I understand, earlier part of your testimony, you said you did not read the bill, is that correct?
Yes.
So you've not read it?
No, I'm here to talk about the constitutional context of nullification in general.
Okay, we're here to decide whether or not we should pass a bill or not, and it would be good to know if any of your comments related to any of the merits of the bill as to whether or not it would be advisable to pass or not. So, would you advise this committee that we should pass a bill that would have us, say, arrest a federal judge for ordering the enforcement of a provision of the Affordable Care Act? Is that what you're advising this committee to do?
No, I'm not sure I would recommend that. I have to look at the bill.
That would be?
I would say that the point I'm trying to make is that in any federal system where you have political societies, there has to be some form of veto by those political societies. Canada, for example, has nullification. A Canadian province can nullify any federal law in the area of civil rights. So if you had, for example, the abortion decision, it's called notwithstanding clause, and Manitoba, for example, can say notwithstanding the simple government's ordinance, Manitoba opts out. So the abortion law would hold in every province of Manitoba. And so what this recognizes is that not every state beats to the same drum. There are reserved rights that a political society has. So even Canada has some form of nullification. Now, what form nullification takes, whether you can arrest a federal agent or whether you have something like the Canadian system, or whether you're interposing it, were you the one? Yeah, who was it? Yes, you were the one that gave the argument for interposition. I would say.
Actually not. I think it was Chairman Delaney.
Oh, sorry.
Yeah.
Yes, that would be a form of a state nullifying or claiming that the thing is unconstitutional. And the method used would be what you were using, what you were talking about, a use of state law versus federal law to jockey the state in position where it can get free what it considers maybe an unconstitutional act. But its motive, it would be in this case the fault that it is unconstitutional and would be asserting its right to do that through its own laws. So we can argue about how you implement this state resistance, but there must be such a thing in any humane, legitimate federal system.
So I want to be clear, and I've enjoyed the philosophical discussion. I've enjoyed it very much. I've enjoyed what you provided to the committee. But I want to make sure that the points that you've made and their applicability to the bill that is before us. And I think that's the important decision. So do you have an opinion as to whether or not we should pass Representative Chumley's bill H3101?
Well, I think I'd just better not give an opinion on that.
Okay,
I need to read it, and I
That
need
would be
to
good.
think about what this would mean if you try to implement it. Because even though you have a right to do something, you want to be successful. And I'm talking about the constitutional context. I'm denying the view of the Constitution that Professor Crocker.
Clearly, we understand that. I think it's important how that applies to this bill, and whether or not it's your opinion to pass it or
That's
not.
my answer.
And so you don't have an opinion for that?
No, sir.
Okay, thank you.
We got lots more questions for you. If you'll take another moment, we'll let you slip out. Chairman Delaney.
Professor Livingston, I enjoyed very much your participation also. And I would ask you this. I know you haven't had a chance to read the Chumley bill, H3101. But if we adopted this, and if we did go out and arrest a federal judge who enjoined the state from imposing some type of direct nullification, if a federal judge enjoined the state of South Carolina from doing that, and then we sent out our police force and arrested the federal judge, do you think we would be successful in our doing that?
Nullification is a political act, and politics is a contingent matter. Whether you're going to be successful or not depends on the circumstances. Some things you can push, and some things you can't push. And that is a nice judgment to be made. But let me say this. Let me say that in Chisholm versus Georgia in 1793, the Georgia in effect nullified a Supreme Court decision, and the House of Representatives passed a resolution saying that if any federal agent came into the state of Georgia to enforce that, he would be arrested for treason and hanged without benefit of clergy. That's a resolution of just the House. Jefferson wrote Madison about the illegality of the federal government putting a national bank in Virginia. And Jefferson said the cashiers and all the rest of them should be arrested for treason against Virginia. So this opinion has been articulated by thoughtful people in American history. What we're to think about that today in South Carolina is a nice question, and I'm not politically wise enough about the situation here to make a judgment.
Well, do you think the federal government would stand by and allow South Carolina to arrest a federal judge from enjoining us from...
Well, you've made an argument. You say that there's a military base right down the street, so to speak, and all of that is true. But let's remember that political authority is based not just on force, but it's based on opinion. And if the central government loses its moral authority, all of its military force is impotent. The Soviet Union had more centralized authority than the United States. But there came a time when it lost its moral authority, and the states began to interpose and nullify, and they nullified, and it went on for some time, until finally Lithuania said, I think we'll just leave it. And the Soviet Union couldn't do anything about it, not because it didn't have the tanks and the Gulag. It couldn't do it because it didn't have the moral authority. The same with the communist government in Poland. So if the United States has, the central government has the moral authority, it can run the troops in. If it doesn't, its hands are tied. And that is a political question, and if it has the moral authority, you'd be foolish to confront it with nothing. But if it doesn't, and that's a nice question, then you can push. If you think you should push, if you think it's unconstitutional, seriously. So I don't know whether the United States has its moral authority or no. I just know that before the election, the approval rating of Congress was 10%.
And what about the president? What was his approval rating?
High.
Right, and so...
No, it's a question.
And he's the commander-in-chief, right?
Slide that.
Right.
But I just want to say, we can't just talk about military bases.
Right.
We have to talk about, the essence of authority is sorry.
And elections have consequences. Is that not right?
Yes. Yes.
Right. And, but in any event, and also the instances you were talking about in the early days of our country, that was in a time when we used to call ourselves the United States, did we not? And we didn't have the federal military might and power, and we didn't have the government.
That's true.
We had a limited government back then.
That's right.
And each state had their own militias.
Yes.
And as a matter of fact, people at that time really were loyal to their states first and the compact second, oftentimes, were they not?
Yes.
But we still have a federal system. That hasn't changed. There are still states. They have constitutions, they're political societies. And if the central government loses its moral authority and is suppressing the states, it's not too clear what it can do. And you mentioned cases where the states could not resist the ID, nullification of institutions, the Marriage Act, and all the rest of it. This goes on because it doesn't have the authority to enforce it.
Or doesn't have the ability, or doesn't want
the central government doesn't.
Right, the central government doesn't. Either doesn't have the ability
Well,
or...
it has all that you mentioned, the Army and all the rest of it, but it doesn't have the moral authority to enforce those things.
Or practically speaking, it just doesn't have the ability. They have to hire more people.
Okay, yeah. whatever.
It's too costly.
Well, if it did hire more people, I'm not sure it could do it anyway.
Could pay them.
I'm not sure it could do it anyway. In other words, there's a point at which federal agents will not come in because they're afraid of the people who do it clean. Not that they'll resist or arrest them, but because of,
Like what eventually happened in the Soviet Union.
yeah.
Representative Quinn.
Yes, sir. I have the distinction of being, I think, the only non-lawyer on the subcommittee, so I'm having to have a law professor and different people, obviously much more intelligent than I am, argue about whether nullification is possible. And of course, one of the greater South Carolinians ever argued for the principle of nullification, and Calhoun and Jefferson also argued for it. So it's just a complex question to me, and I think it even goes back to there's a fellow that wrote a piece on this. I think his name was Clyde Wilson, who was even talking about the Confederate States of America and how they argued about whether to form a Supreme Court in the Confederacy. And so these are complex issues and have a lot of nuanceical points to them. But I'm not going to ask you to comment on the bill, but that's before us. And I'm, as somebody maybe a little more open-minded about this principle, I look at the bill and I've been struggling on how it would be implemented. And so, that we keep giving the instance of arresting a federal judge, and I know lawyers think that's a scary thing. Sometimes federal judges maybe should be arrested. But the greater issue, though, is I looked at the bill, and it basically says that anybody, whether working for a private corporation or the federal government, who tries to to enforce or go by the Affordable Care Act has committed a felony and should go to jail and pay a fine. And so I just thought I'd go through what would be the practical application of that. And so, for example, I think about really the everyday citizen, what's right or wrong. You got somebody that works for Blue Cross Blue Shield or an insurance company, and they decide, well, we're not going to give this child who's 26 years old family coverage, that's one of the things that Obamacare does. It says if you're a child and you're on a policy, you can keep that child up till age 26. Or there are other things about covering somebody with pre-existing conditions, for example. So if an employee at Blue Cross says, well, South Carolina has nullified it and I'm not going to follow it, and then that insurance person is faced with potentially being in violation and maybe being sued, and they say, okay, well, I'll go ahead and give you the coverage. They'd be in violation of Mr. Chumley's bill. And is that a right thing to do, to say, okay, to an insurance person who's just giving coverage to somebody under this law? Because there are a lot of bad things about Obamacare, and it's an abomination as far as I'm concerned. But is that a right thing to do, to maybe place somebody in jail that's just an everyday citizen that's working for an insurance company that's just implementing things that maybe some people in this room agree with, the mandate to give coverage to pre-existing conditions? Is that right? Is that right to do that?
Well, I better not comment because.
You see, that's what we're struggling with.
I see.
Loaded question.
The question. Jefferson said in the case of federal intrusion into the reserve rights of the states, the state must decide the level of the infraction and the means of redress. And the question is has the infraction risen to the level of arresting federal officials? Can you not imagine an obnoxious intrusion which would rise to that level? Is there nothing the federal government could do to a local society, an American state, that would not require the protection of its officials in just the capacity you mentioned?
Well, in fact, I agree with you on that point. I guess I'm worried about the margins.
If it is possible to entertain that within our federal system, not the unitary state system, that's something the Constitution is, but in our federal system, then the question is this a prudent thing to do? The first, does it rise to the level of that sort of remedy? And secondly, is it remedy? And I just can't answer those questions, but that's what you have to think about. So I would not put it out of bounds to entertain that thought, but again, that is really a political question as to what is prudent.
And that's what I started with, because I think it's not the big things, it's the marginal things that worry me about doing it. But I do think there are cases where we should, to be honest with you. But I wonder if maybe in the margins of this bill, we're doing some things we shouldn't. And I'd love to hear your opinion on that once you have the opportunity to read the bill.
Yes, okay.
Mr. Chairman.
Representative Poe. Then Representative McLeod, and then Representative Smith.
Professor, I know we're going to take more time than it took for you to ride up here if we keep getting to the questions, but I tried to do a lot of reading when this first came up to understand it, because I've told my friends I take seriously my constitutional oath and making
Yes.
sure that we're doing
Yes.
what we're supposed to be. The flip side is, I think if you took a poll, I don't even have to take it out there, if you took it up here, we've got as a caucus, we're going to do everything we can to not implement Obamacare. So what we're trying to probe is the bounds of what we can do based on our oath. One of the things when I was reading nullification and interposition, and sometimes they're used together. I think Johnson Calhoun said they were the same, but sometimes they're not. If I understood, you kind of start on this, but interposition is really, we do the things like we're doing today, where we say that we as a state believe this is unconstitutional. And part of what we're doing is sending up a flare or a flag to our fellow states in this compact to say, we see a problem, and we hope that they in turn see that, okay? And that's kind of the beginning. What I kind of see sometimes is a distinction between interposition. You could argue that the marijuana laws on the other side of the country, that's their first flare, that they think marijuana is not an issue that the feds do think, and other states may join on. Is that the kind, again, knowing you hadn't seen the bill, but
Yes.
those type things are the mechanics that we have to do, using Representative Delaney's bill, if there's things that you touched on.
I think that's what he was describing, and that's what Madison talked about, because he talked about interposition in the Virginia resolution.
Absolutely.
Interposition. And Jefferson used the term nullification.
Right.
But it has to rise to a certain level for nullification.
Right.
And nullification is that you will not enforce it, and presumably you would use
Forced to not.
you would use state laws to do what you have to do. But that's pretty serious, obviously.
Right.
Especially, and you're right, more so now than it was when Jefferson was around. But interposition it is a case of what I'm talking about. It is a political society. It denies this notion of the Constitution of the United States. It recognizes that it's a compact political society. The political society steps forward to protect its citizens in whatever way it can prudently and constitutionally do to protect them. And that would be interposition.
And I think I took notes when you were speaking. Numerous times you said the states, plural. And so the key in interposition is because, of course, in South Carolina, if everybody in South Carolina chose to do something election-wise, we couldn't get it done by ourselves. We can fire the first shot. Of course, we've done that before. We can fire the first shot. We can do these things, but we need to do what we can within the context what we can to try to rise against that. Because you kept talking about the moral authority to do it.
Yes. So, well, politically, that would be wise to get the majority of states. Okay. But one has to keep in mind that if you believe the states have reserved powers, and these are not defined as unenumerated, then only the state can say what they are. It might be there's only one state in the United States. Let's suppose the Supreme Court extends Roe to include infanticide within the first week, as the Romans did. Now, a state, and suppose every state goes along with that. They don't like it, but it doesn't rise to the level of, but one state might say, look, we reserve the power to regulate this sort of thing.
Well, that might be when we arrest the federal judge.
And we're not going to do it. And so you don't need, it'd be nice to have the political support, but you don't need it. That's why Canada allows the province to nullify in the area of civil rights. The province can opt out.
But Canada's constitution is different than our constitution.
Well, it's a federal constitution. It's a federal constitution. Well, see, that depends on what you mean by the constitution. I've described it as a compact between the states. Other people describe it as a unitary state. The central government is supreme and can define the limits of its own power. I don't recognize that as the U.S. Constitution. It doesn't matter what the Supreme Court says, or even for 100 years. I'm a citizen who can read it. And so we have a disagreement here, very deep disagreement, but they're thoughtful people on both sides. So when you say you've taken an oath to the Constitution, I would ask which one? I'm not saying that.
I
I'm
understand.
just saying that Americans need to realize that we don't agree on this. And these are honest disagreements. I can appeal to Madison, Jefferson, and a whole tradition of that holds to the compact here. And others will not. And so how we communicate on this is a difficult question.
Thank you, sir.
But, yeah.
Representative Cloud.
Thank you, Professor, for being with us. We appreciate your comments. Tell us how long you've been living in McClellanville.
Oh, well, I'm from that area. Originally, we had a summer home there, so we would go from Emory to McClellanville in the summer, about 1995, and I've been there a couple of years.
About how many years were you a teacher at Emory University?
I can't remember. About 30 years.
30 years, I think maybe that's long enough.
It's long enough.
Well, I want to ask you about horizontal nullification, basically.
Yes, sir.
Is it correct to say that the United States Constitution allows the President of the United States to veto an act passed by the two bodies in the United States Congress?
Yes,
And is that an example of horizontal nullification?
yes, it's a veto.
Is it also correct to say that the Constitution allows 2/3 of the House and Senate, both bodies, to override a veto? Now, would that be an example of horizontal
Yes,
nullification?
yes,
Is it correct to say that the Constitution allows the United States Congress to decline to fund some program? And would that be an example of horizontal nullification?
yeah, I gave that as an example.
But I'm just asking
Yes,
you
yes,
the
the
question.
House can do that.
Okay, and now with respect to the doctrine of judicial reviews, which emanates from Marbury versus Madison, is it correct to say that the U.S. Constitution allows that? It's not specifically mentioned in the Constitution, but would you say it would be another example of horizontal nullification?
Supreme Court, well, the Supreme Court, well, this is a question.
Sir?
This is a question. Does the Supreme Court have the final say on how to interpret the Constitution? And here we're going to reach disagreement. The court acts as if it does have this power, and many people acquiesce in it. I don't believe it does. And that there are other thoughtful people that don't believe the Supreme Court has the final say on how to interpret the Constitution.
Well, would it be correct to say that we have practiced and accepted that since the case in early, about 1802, entitled Marbury versus Madison?
It's been contested all along the way, including secession, including nullifications of New England, including nullification of South Carolina, including nullification in Arkansas, and in other cases, and these were defeated. Not all of them. Calhoun won. I mean, South Carolina did get the tariff changed. So it's been a contested thing. I certainly agree that in the current regime and the way it thinks of its history, you're right. The Supreme Court is seen by many people as having the final say.
And that would be essentially a horizontal nullification.
Supreme Court, yes, if you accept that, it's horizontal.
Thank you.
Yeah.
Now, with respect to vertical nullification, my recollection is there are no places in the United States Constitution which mention the word interpose, or the word interposition, or the word nullify or nullification. Do you know of any instances in the Constitution where they do that? No, you do not. So as far as you know, there are no...
It also does not give the Supreme Court final say over how to interpret the Constitution either. There's no way can you find that.
I understand that, but we now moved on to vertical nullification. So do you know of any instances where vertical nullification is mentioned or proved within the United States Constitution?
Yes.
Lay it on us.
Article 7
What does it say?
says the Constitution will go into effect. It's a compact when 9 states ratify, leaving the other 4 to do what they want to do, which means the states are sovereign societies. Each state ratified it for itself, with no authority to bind any other state. And that is state sovereign. The 9th and 10th Amendment say that there are undefined and unenumerated, meaning it is undefined and unenumerated powers that are reserved by the states of the people. Now, if there are undefined and unenumerated powers reserved by the states and the people, they have to be able to exercise them. And if the central government intrudes into those powers recognized by the 9th and 10th Amendment, there has to be some sort of vertical resistance to it.
Okay, so let's go back to the question. Is it correct to say that nowhere in the United States Constitution is the word interpose mentioned, interposition, nullify, or nullification? Is that a correct statement?
Yeah,
Thank you, sir.
because there wouldn't be anything in there because all those are locked into the 9th and 10th Amendment.
Thank
That's
you
why
for
they
your
were
response.
that's why they were put in, to protect the states from the central government.
Thank you, sir.
Representative Smith.
Thank you, Mr. Chairman. Professor Livingston, we know about your service and your time at Emory as a professor, but you've also served as a leader of the League of the South, is that correct?
No.
You've never been affiliated with the League of the South?
Oh, I was a member, yeah.
Okay, and you've written extensively about
I
secession.
left it after a few years.
You left it after, you never served as a director in any way?
I started an institute, I headed an institute for education, but I could see the league was not going the right way, so I withdrew.
So you
I
reject
I did
the,
run that for a while.
but do you advocate secession, Professor Livingston?
Advocate
Yes,
secession?
have you written papers advocating secession?
I think if you agree that the Constitution is a compact between political societies, no question about it. It is an option available to an American state if, with prudence, you wouldn't, you have to have good reason and so on, but yes, yes.
And do you support the tenets of the League of the South? Do you
I'm not a
advocate
member
those?
of the League of the South, so obviously I don't have anything to do with it.
But you did it one time? Is that correct?
I told you, yes.
Okay, thank you.
I was a member of the League of the South.
Thank you.
And I believe secession is a constitutional right that American state can exercise.
Would you advocate South Carolina secede?
I'm not advocating any, whether a state, I'm talking about the principle, the constitutional right. Whether a right should be exercised is a question of prudence and morals and all the rest of it. But yes, there could come a point where the state would be able to withdraw.
Would the imposition of the Affordable Care Act be a basis to secede from?
No,
No, it would not?
I don't think so.
Okay, thank you.
It has to rise to a certain level for that action to go on. By the way, the Soviet Union, Article 17, recognized secession of the states. Stalin, of course, would have paid no attention to that. That's kind of interesting.
Thank you, Professor. All right, Dr. Tom Kendall. If you'll introduce yourself, tell us where you live and what you do.
Thank you. I am Dr. Tom Kendall. I'm a family physician in Greenville, South Carolina. I've been in Greenville since 1976, primary care. I also have represented an organization called the Association of American Physicians and Surgeons, which was born in 1943 to oppose the socialization of healthcare in America. I serve as president-elect of that organization.
Thank you.
First, I would like to thank Representative Delaney and Bannister for this opportunity to address the subcommittee. My purpose is to convince you of the following. Number one, there is a war on doctors. Number two, the Affordable Care Act is bad for South Carolina. And number three, innovation and creativity can succeed when given freedom. Number one, assault on the physicians of America has been waged by our federal and state governments, the insurance industry, our legal system, and our hospital associations. The regulatory, administrative, and political chains that have been forged to accomplish so-called social justice and universal health care have influenced doctors and have put pressure upon them to compromise principles of honor, nobility, and personal liberty. The inequities of the government, insurance, hospital, cartel
which have resulted in increasing costs in medicine by complex billing schemes using deceptive copay enticements and inflated charges, serve to frustrate medical professionals and their patients. These factors, alongside the liability issues, are creating an environment that is enticing more and more physicians to abandon independent private medicine and their patients for industrial, government, institutional medical care. This war on doctors is a symbol of the war on liberty. The patient-physician relationship is under attack. Fee-for-service is being abandoned for comprehensive health care coverage, which will not be personal, individualized medical care with a focus on what is best for the patient, but will be cost-driven, managed care that must meet imposed bureaucratic standards. Doctors will leave medicine, coerced by the ethical changes of politically imposed tyranny. In fact, accompanying me today from Greenville is, I believe, one of the finest cardiologists anywhere, Dr. Francis Sandroya. He resigned his hospital position 2 weeks ago amidst conflict of conscience when an administrator said to him, the patient was not his. There is a war on doctors. Strategic outcome of today's meeting will determine whether you will fight to preserve our God-given freedoms. Number 2, the Patient Protection and Affordable Care Act, which I believe is neither patient protective nor affordable, is bad for South Carolina. I reject the notion that this legislation is constitutional, sir. Although it falls short of the evil and immoral underpinnings of abortion, it is as unconstitutional as Roe versus Wade, which our U.S. Supreme Court states is constitutional. Much of the uncertainty that surrounds this legislation that has usurped our Constitution gives unbridled power to undefined agencies and policies. Particular discretionary authority is given to the Secretary, who will establish many of the agencies and the policies that will be enforced. This is not a limitation of enumerated powers. This is a mechanism to impoverish the citizens of South Carolina and other states of our nation, first economically, then politically. The Affordable Care Act is configured in such a way that it is impossible to know its ultimate destructive impact. The statutory language makes reading tedious and understanding unlikely. Provisions include progressive taxation with redistribution, regulations, legal consequences with litigation, prosecution, penalties, civil, administrative, and criminal, special interest groups, and social engineering. The key themes in the bill are redistribution of wealth, political and racial favoritism, and expansion of the welfare surveillance state. For these and many other reasons, Obamacare is bad for South Carolina. Number 3, innovation and creativity can and will succeed if South Carolina is given the opportunity. As President-elect of the Association of American Physicians and Surgeons, I'm proud to introduce you to the Delta Force of Medicine. This organization, since 1943, when Murray and Dingle from Michigan proposed the socialization of health care, has stood in opposition to that. In 1994, single-handedly stopped the committee meetings that Hillary Clinton was carrying out in Washington, D.C. to oppose Hillary Care. It has protected the patient-physician relationship by defending the practice of private medicine. There are answers to the problems facing our state. First, the questions must be articulated. Have we departed from our original charters? Yes, we have. It is obvious when considering Thomas Jefferson's perspective regarding the Creator that our American Republic and its documents were framed with biblical presuppositions. The family, the church, and civil government serve divine purposes and function according to jurisdictional operatives. Specifically, government exists to punish evil, thereby protecting the innocent. Cornelius Van Til said, "Culture is religion externalized. Our societal character reflects our faith, individually and collectively. Healthcare is not to be government enforced. Healthcare becomes a monster when it is politicized." My concluding remarks will illustrate two examples of innovation and creativity that will be models for South Carolina to consider. The first is the Surgery Center of Oklahoma. This is a private, third-party payment, independent, non-governmental surgical facility that posts its fees on the web. You get what you pay for, and no more. And the cost of this care is 1/5 of the hospital costs in that city. It can be found on the website www.aapsonline.org. The second model is found in New Jersey. Charity Care is a major provider through the Zarephath Clinic. The New Jersey legislature is considering a proposal that would provide complete malpractice coverage for doctors who donate 4 hours a month to charity care. The Volunteer Medical Professional Health Care Act, Senate Bill 2231, New Jersey State Senate. Thank you so much for letting me speak to you today. I could have put my white coat on, but that might have been too much theatrics. But it is interesting. There are evidences of reversals. It's usually that the attorney follows the doctor. Today, he preceded the doctor. But that might speak to other considerations. But this opportunity you had to put an unruly and arrogant child, the federal government, in its place and be the responsible parent will be the most important function you will do in this legislative cycle. Don't miss it. Do all you can to protect our liberties. Thank you very much.
All right, we got a couple of questions if you'll take a few. Representative Smith.
Thank you very much, Mr. Chairman and Doctor. I appreciate your time here today and your comments, and listened very carefully to them. And you know, as Chairman Delaney stated earlier, there's a lot that's yet to be defined. January 2014 is when many of the provisions of the Affordable Care Act go into effect. And it's important for us to do our job as best we can to understand those things. And you listed a number of things where you were citing why we should be opposed to this and why Obamacare, as you described it, is bad for South Carolina. And one of the things that I took note of was racial favoritism. I'd like for you to define where in the Affordable Care Act it provides for racial favoritism.
All right. I consider it's better to give someone a fishing pole with some bait and show them how to catch a fish than it is to continue to giving them fish. And I do believe
Who's them?
the ones that need the fish, the ones that need the situation, the ones that need the service. I use the word cartel as well. A cartel is an organization or an association of entities that provide goods and services, right, that limit services and increase costs for their interests. And I believe that exists today, sir. And so as far as the answer to your question,
Yes, answer the question.
I believe that any group of people, be it this race, this group, this religious perspective, whatever it might be, is recognized as having special needs in regard to how this is going to solve their problem. And again, I think associated with this, and I did use the word chains, I do believe associated with this poorly understood proposal for all of us to be under, that there are chains affixed to it, and there are certain people that are more likely to be chained than others. And I think that is a disparity in this bill, in the Obamacare bill.
All right, you talked about them and they, and I just want to make sure I understand. if you would say exactly what race and what is the favoritism, what race are you talking about?
You've got to read the bill, sir. It's in there. I recommend.
I've actually read, I know a lot about this.
Have you read the whole thing, sir?
No, it's about 23,000 pages, I think, or something like that.
2,300.
2,300 pages, but it's a lot of, but my point is that you have stated, I don't believe that is in there. I disagree with the assertion that you made that there is racial favoritism in the Affordable Care Act. You have made that assertion. I would like you to state for this committee what race you're talking about and what favoritism you're talking about. You said it's in there. I'm asking you to say what it is.
I made some notes. They're not actually in my hand right now.
Okay.
As I was going through that, what section, I'll be glad to follow up with you and give you that information.
But you can't identify it now, so you don't.
I don't have it before me right now.
Okay.
And again, that's part of the difficulty of this draconian law. And again, I think it's fitting in this context that an attorney was the first one to speak today. Before the physician. And we're talking about Obamacare. We're talking about medicine. We're talking about freedom.
Any other questions for Dr. Henry? Representative
Yes, sir. Just briefly, I just got one point, Doctor. I agree. I wrote your points down, and I agree on the war on doctors, the affordable care, and the freedom to open up and choose. You know, basically it's free market, and you can prove it can be cheaper. I see the cartel situation you're talking about. Ultimately, I think what we got lost, I got a lot of friends that came here today. They might not be friends when I get through, but they were friends when they got here. And the issue we keep kind of missing is and I think I've said this before, Obamacare is the evil. Unfortunately, what we're tasked with dealing with now is how can we fight the evil. So there is a lawyer part underneath, if you understand what I'm saying. And that's the reason we hear from the lawyer, because we're trying to decide, can we arrest the federal judge under the first bill, or can we do the things we're doing? So I think you know this, but I want to assure my friends again, as far as being against Obamacare, I would say the majority of the people, I can't speak for everybody up here, and certainly in the room, see the same pain you delineate. The question we're wrestling with today, I think Mr. Quinn said, is how do we ultimately tackle what's before us with the authority we have. So I think we're fighting in the same direction. We may be fighting with different weapons.
I appreciate that, but I don't see any doctors up there, and I do recognize that this war is fought at different levels with multiple strategies. And I recognize that most of the people I asked today about Obamacare in my office, I'm finding not just a majority, but almost universally in this context, no, I think it's bad for South Carolina. I don't think it's good for me. In other words, they will say that. And so, unfortunately, doctors, again, part of this war, I had to cancel some patients today. I'll be going back to see patients in about 2 hours. And I haven't had to impose upon them today. For what do I believe to be something minor, something insignificant? No. I believe this is the heartbeat of our state and of our nation. And that if we don't recognize this now and depend upon you, and that's why I put it upon you, you're the ones that are doing it for us. Or doing it to us.
Representative Quinn.
Just to the point that Mr. Smith was asking on, there's no question that Obamacare, that the law allows for the secretary to give greater benefits, but based on race, there's no doubt about it. Now, there may be issues where there's racial disparity in some cases, and that might be addressed, but the idea that that's not a part of the powers that have been given to the federal government through this bill is very clear. You're right.
Thank you, sir.
Any other questions for Dr. Henry? Representative Black.
Doctor, thank you for being with us. I was struck and taken with your concept of a war on doctors, and I kind of want a little better definition. We can talk with this. We talk about an impact on your ethics, or your pocketbook, or your morals, or what kind of war would it be on you as a medical doctor? Define this concept that you have outlined for us.
Well,
Your life.
I'll illustrate it here today that this is the first time I've ever addressed any subcommittee in South Carolina. I've been told by a previous representative years ago that maybe I ought to be coming down here talking because the foundations are being laid for things that would take away the liberty for me to go into my office to have a patient-physician relationship that is not imposed upon by federal bureaucracy, by federal power, by state power, but my relationship remains with my patient. And I believe that to be a sacred trust. Doctors,
So
unfortunately...
part of your concept would be a war on your physician-patient relationship. It'd be one
No
component.
question about that, yes, sir.
Okay, give us another component.
Another component of the war,
Correct.
the fact that doctors are leaving medicine because they do not want to put up with the bureaucracy that's coming upon them because they're afraid they might code a wrong procedure. There are doctors in federal prison right now because they have coded the wrong procedure. They were not convicted of fraud, but they were found to be negligent in the way they put a record in the chart. And I'm sorry.
So that would be a war on your practice of your profession.
Okay, yes, sir.
What else?
Well, again, the idea that the best cardiologist that I know, and if you had a heart problem, I would refer you to him, asked about something for his patient, and the administrator of that facility that is over him, that gives him his check, said, this is not your patient. In other words, the patient is that product, that one of the institution that doctor is working under. So the war is against the private practice of medicine. The war is pushing doctors away from the independence and the liberty needed to provide what they think is best for their patients and find out what best works for the institution. Maybe government, it may be a cartel, it may be an insurance.
So basically you're saying that the patient is the patient of the medical doctor and is not the patient of the hospital.
Absolutely. Absolutely. And I hope that's the way you see your doctor when you go see a patient, go see a doctor.
Sometimes I do, sometimes I don't. So now any other elements of your concept that you can illuminate us on what constitutes the war on doctors?
I thank you for that. You asked, was there a war on ethics?
That's one thing.
And I'm telling
How about your pocketbook? Is it a war on your pocketbook?
I haven't said anything about that.
But I'm asking.
God butters my bread. I'll take care of patients as long as He gives me strength and energy, and He'll give the patients resources to give me what my service is worth to them. That is not the primary motivation for my being.
So you're not motivated by the economics of this of the war on doctors?
I'm not an attorney, and I'm not an economist, although I am a husband, a father, and a businessman. I'm a father and a husband and a doctor. And I'm trying to put those things together in a daily experience whereby I can come home and not feel like I'm a slave of the state.
If you could hold your applause.
Well, we thank you for your dedication, your patience, and we thank you for your...
Thank you, Dr. Kendall.
And I thank you.
Trevor Tyson.
I believe Mr. Wiseman is second after me. I was going to let him go first, but after him, if that's okay.
That's fine. Wise.
Good afternoon, ladies and gentlemen. My name is William Wiseman. I'm a citizen of York County, and I live in Fort Mill. After hearing all these gentlemen give these reports today, I'm not sure my remarks mean a whole lot. I think you all need wisdom. You need the wisdom of God. You've got some serious things before you. I'm reminded of King Solomon having to decide to divide the baby in half to see who the real mother was. And I'd just like to bless you with wisdom and the mind of God, that as you sort this out, that you will do it with the wisdom of God. Someone has already said, and I have in my remarks, that the Patient Protection and Affordable Act, commonly called Obamacare, is not affordable, neither does it protect the patient. I think it's absolutely wrong, and I think it's unconstitutional in its inception. I base my belief on the fact that it doesn't protect either the patient or it is portable, and that makes the title a misnomer. As more details and understanding of this act come to light, it becomes quite clear that it's designed for control of the population, and the controller is the federal government. I don't know about you, but we the people seem to be becoming we the government. And I don't need any more government control in my life. Would any of you vote for past legislation that you have not read? I would hope not. Yet, this act was passed, and it was done so without being read by the officials that we elected to protect us, to protect our interests. And even if some of them had read it, as was said here, they need an attorney to help them interpret what they read. What kind of legislation is this? On a weekly basis, more and more disturbing details emerge that cause any knowledgeable person to back away from this albatross. Think of it. The most sweeping and intrusive piece of legislation ever to pass American law cannot be understood, not only by the average person, but even by the people who passed it. Do your constituents understand it? I assume all of you are aware of some of the more onerous parts that are coming to light as of late, like a lot of new taxes that are being added. One of these is tax on medical devices. It's already led to the closing of one plant that produces these. Do any of your constituents use medical devices? If they do, they can expect to be paying more for them. The minimum cost of insurance, $20,000 a year for a family of 5. This was just released a few days ago. Can your constituents afford $20,000 a year to pay for their insurance? Americans can no longer use their health savings account for pre-tax dollars to purchase over-the-counter medications. This hurts your constituents. How about violation of our religious freedom? I'm sure you're familiar with the numerous cases involving the violation of First Amendment rights. Once the government can determine our religious freedom, we no longer have any freedom, ladies and gentlemen. Just look at any society where a tyrannical government has done this, and the devastating results are abundantly evident. This also leads to mercy killing, leads to abortion, euthanasia. I'm sure that you have informed your constituents about this. How are you going to explain to your constituents the home visitation programs for families with small children, where the government will be telling them how to raise their children, using activities designed to help parents become full partners in the education of their children? This is nothing but brainwashing, and it parallels what has been used in other socialist experiments that have failed miserably. How many of you want your children to be brainwashed by the government? Health and Human Services Secretary Kathleen Sebelius said on Monday of this week that President Obama's health care law is here to stay. But it cannot fulfill its promise if states do not expand Medicaid and the uninsured do not reach for the benefits designed to put coverage in the reach of millions more Americans. How is this going to play out with your constituents? These are but the tip of the Obamacare iceberg when it comes to bad legislation. I urge each of you to search your own heart, decide where you stand on the issue, and make sure you consider the consequences for your children, your grandchildren, and your constituents. Thank you very much for allowing me to speak.
Thank you, Mr. Wiseman. The next person, Trevor Tyson, you want to be heard? All right.
Thank you for your time this morning. I've read the Constitution, and not to overlap too much what other people have said, but I just don't see anywhere in there where it allows the U.S. government to take over, almost 1/7 of the entire economy. their powers are few and defined. But as far as the Constitution goes, I don't see how it's constitutional for bureaucrats or commissars to do home inspections on immunizations. That's in section 4204. Telling you how to raise your children and, if necessary, doing it by force, section 2951. Or where government grants have been made available for institutions that perform mercy killing, abortion, or euthanasia. That's in section 1553. But regarding violation of religious freedom, this isn't like something that theoretically might happen. This is already going on. I'm sure you've heard of Hobby Lobby, Christian business. This is in Christian Post contributor here, where they're facing 18.2 million in penalties already, and the meter's running. They haven't had to pay that yet. I think they managed to put that off, but according to this article here, that's what they're already facing. And why? It's because they just don't believe in having to provide contraception for their employees. So how is it that we've got to the point where a company can be fined over $18 million and growing just because they don't want to provide contraception to employees? It just seems pretty outrageous to me. And I don't think it's going to stop there. That's just one example of the violation of religious freedom, the pressure that's already coming down. Respect with what the doctor was mentioning about doctors not being on board with this, and this is an article out of Forbes. 83% of physicians are surveyed are threatening to quit because of Obamacare. 90% feel that healthcare system is now headed in the wrong direction. I mean, if even 10% of these doctors make good on their promise, it'll be an absolute disaster for us. And with regards to the taxes, I think Mr. Wiseman mentioned there was like 20 new taxes, I think, and what that means is about another $500 billion over the next 10 years. So it's not chump change. And as far as what we can see coming, we can look to somewhat to our neighbors to the north in Canada. In 2011, over 46,000 Canadians sought Medicare or medical treatment outside of Canada. That's just the ones that can afford it. The ones that have the money to fly, travel, and pay for all that themselves. There's many more, of course, many times more that can obviously do that. But from 1993 to 2011, the wait times in Canada have increased 104%. So their costs are going up, and the system is under strain, and it's not working. Socialism historically has proven not to work. And as far as that goes, the average wait time now for elective treatments now is up to 19 weeks. That's just to see a specialist. This is out of the Daily Caller News Foundation, this article. And that's just 19 weeks to see a specialist. After that, it goes up to another 9.5 weeks average before you actually get treatment. Now that's for elective surgeries, but for people with more serious ailments or life-threatening ailments, and I don't have those numbers unfortunately in front of me, but the reality is people do die on waiting lists. You're not technically turned away, if you don't make it when your number comes up, it's just too late. Or by the time they get to you to treat you, cancer or tumors, whatever it is so far down the line that they can't help you. And that's not uncommon, and I don't think that's the direction that the United States wants to go, and I don't think it's the direction that South Carolina wants to go. So just thank you for your time.
Thank you, Mr. Tyson. Chance Braley.
Thank you for allowing me this opportunity. I'll be much more brief than those preceding me. I'm from Spartanburg County, District 34, small business owner. And while I'm going to be brief, my passion is just as strong as everybody else here that's spoken. I believe that this is an encroachment on our rights and liberties and right of choice. Not to mention the financial burden that is creating for small business owners, or all business owners for that matter. So I applaud Representative Chumley for putting something on the table. I expect our state legislators to protect us from our federal government if they're encroaching on our rights. you chose to run for office. Someone chose to vote for you. So therefore, you are taxed to go do what they ask to the best of your ability. And so what I'm asking is that put your heads together and come up with the best possible bill, whether, I'm not sure what's right or wrong in either one of these bills, but I would task you to come up with the best possible bill, turn this, and if we don't, I mean, if we don't fight it, if there's a small voice heard, the federal government's just going to continue to encroach. They need to know that at some point in time, we're going to stand up against what they're imposing on us. So I encourage you and I pray for you to come up with the best possible choice and that we're successful. Thank you for that.
Thank you, Mr. Braylon. Next is Don Rogers.
Thank you, Mr. Chairman, and thank you, committee members, for this opportunity. The attorney that spoke first said what was to me an astonishing generalization. He said in most legal situations, there's two hands. He said in this one, there's only one hand. In other words, there's only one opinion. He has it, and it's right, and that's the end of the story. I find that amazing. We've had an entire history in this country of an opposing opinion. Those by our founding fathers thought that we were creating a government in which there would be divided sovereignty amongst the states and the federal government. The states created the federal government. We have on that side our founding fathers, Thomas Jefferson, Alexander Hamilton, and a long list of others. We have all that was said in the ratifying convention. We have the Federalist Papers. We have the Anti-Federalist Papers. We have all manner of brilliant and bright people saying there is two hands here. To say that it's not controversial and it's concluded is, to me, ridiculous. Why is it important? Because throughout human history, governments have been the main cause of human misery. The whole purpose of our Constitution is to contain the general government, the federal government. That's the whole purpose of it. And to say that these folks signed off on this thing and thought it would be just hunky-dory if the federal government's deputy, which is the Supreme Court, was going to decide in a contested argument between the federal government and those that are contesting, those that were a party to that agreement. The states are one of them. And so we got an arrangement where the party that has the power gets to decide. It's like I could have my mother come and present me in court. I'm sure she would if she was still here today. That's prejudice. You cannot have a deputy to one of the parties having the power. This is a federal government. The federal system that was created here was the greatest gift to mankind. What's at stake here with this Obamacare is the federal system itself, which means the states have certain sovereignty, and it's stated in the 9th and 10th Amendment of the Constitution. We cannot get around that. So, let me ask you this. If there is an unconstitutional law passed by the federal government, are we obliged to abide by that law? Or do we have a responsibility and a right to deny and not go by that unconstitutional law? This comes to the basic question: who gets to decide what is constitutional? And it cannot be in a civil society in which people have their own sovereignty. It cannot be the sole responsibility of a deputy of the federal government to have final say. If that's where we are, then no, it'd be just like any other government in the world, and it would be totally out of the reach of the people. We have this one last opportunity to save America. This is the last opportunity. I'm asking you to take a chance. We don't have time now to go into the history of the successes of nullification through the history of this country. There have been some greats, and some have been mentioned. There's all sorts of additional opportunities once we have stood up and said no to Obamacare. Don't be afraid of the future and what might and might not happen. Make the first step and stand there. And we'll deal with it then afterwards. Thank you very much.
Thank you, Mr. Rogers. Next is Harry Kipler.
Good afternoon, Mr. Chairman, members of the committee. My name is Harry Kibler. I reside at 199 Williams Road in Pelzer, South Carolina. The only letters I have in front of my name is Mr., and the only letters I have in the end is Junior. So I'm not quite as intellectually adapted to speaking as many that have already spoken today. And I pray that you will grant me a little leeway because of that. As I've sat here today, of course, I've got a printed testimony that I would like to read to you, and I believe you all have a copy. But several things that went through my mind as I've listened to the back and forth. Number one, I'd like to say that some of you I know personally, and I consider friends. Some I don't know that well, but here today, this is not about who is friends with whom. As a matter of fact, I don't consider any of you here today in this chamber my friend. I don't consider any of you my enemy. I consider all of you our servants. I don't say that, use the word servants as in I'm here ruling over you. But I do say that to make sure that there's no preconception that you're here to rule over us. We're at a crossroads today in our nation and our state, and I will not bore you with a history lesson on the founding of our great nation. But I would like to remind you of some principles on which it was founded. That our unalienable rights do not come from government, they come from our Creator. That to secure these rights, governments were instituted among men, deriving their just powers from the consent of the governed. Whenever any form of government becomes destructive to these ends, it is the right of the people to alter it or to abolish it. And governments that are long established should not be changed for light and transient causes, but when a long train of abuses which are designed to reduce them under absolute despotism, it is their duty to throw off such government and to place new guards for their future security. As some others have stated, the federal government was never a party to the contract that created our United States. The states were the only party to that contract. Refusing to obey unconstitutional acts is not un-American. It is not illegal. It is not unconstitutional. It is your duty and my duty. In Proverbs chapter 3, verse 12, it states, "For whom the Lord loveth, he correcteth, even as a father the son in whom he delighteth." If we love our nation and our Constitution, we must correct and resist unconstitutional acts as they occur. We have grown accustomed to simply following orders perceived to come from authority, but we must question from what authority the order comes. If authority was never given, it is no authority at all. The federal government has no more authority to force me to purchase health insurance than I have to punish someone for speeding. as others have more eloquently than I would be able to tell you, I would encourage you to truly study the often quoted supremacy clause of our U.S. Constitution. Yes, Article 6 is there. Yes, it does say that the supreme law of the land. But you cannot get to that portion of that statement until you look at where it says, shall be made in pursuance thereof. Any act of Congress that is not made in pursuance of the Constitution is unconstitutional, and therefore no law at all. No honest consideration of the language in the Supremacy Clause could lead to the conclusion that just any act passed by Congress and ruled upon by the Supreme Court is the law of the land. History dictates a clear understanding that in Nazi Germany it became lawful to exterminate millions of people because of religious intolerance. Although this is an extreme example of allowing obvious injustice to humanity, so is the notion that just any act of Congress is constitutional. We are at a time in our national history that will be studied by generations to come, and the eyes of our nation are upon you. I sincerely pray that you will show the courage and convictions of those that sacrifice their lives and fortune to safeguard our freedom. I also pray that you would comprehend the unmistakable fact that once the Patient Protection and Affordable Care Act is implemented in our state, our lives will be forever changed. Our employers will be forced to reduce their workforce. Our doctors will be forced to compromise their relationship with their patients. Our schools will be forced to provide medical services to our children, possibly without our consent. And our homes will be open to inspections to determine our ability to nurture the mental health of our children. Just one generation ago, this usurpation of liberty would not have stood a chance. What we're really talking about here today is that, however, with the increased dependency on federal money, we are trading liberty for temporary freedom, or temporary security, I'm sorry. Before you cast your vote on the issue of these two bills, I would ask each legislator on this committee, when did South Carolina confer upon the United States Congress the authority to mandate the purchase of any tangible item which touches our lives? If you cannot provide clearly evidenced surrender of this authority, the authority remains within the confines of the body of the General Assembly of this great state. The issue of protecting our Constitution and freedom may be temporarily decided in this committee, but it will be permanently decided by the citizens of each House and Senate district in South Carolina, for you are the current guards of our future security. My only additional comment was, we talked about a bill that would allow our Attorney General to sue on our behalf. Mr. Delaney, I appreciate your bill, I appreciate your efforts. But if my daughter needs a heart transplant and they say she can't have it, we won't have time to wait for an Attorney General to file a lawsuit. It does not go near far enough, sir.
It's not a lawsuit, it's an injunction. You get a temporary restraining order, even without testimony, just a couple of days, and you can have another injunction. It's not a lawsuit, it's not an injunction.
I stand corrected.
Stopping procedures that are not in the best interest of people of South Carolina. It can be done in just a couple of days.
Thank you, sir. That is all my comments. Thank you all very much for listening.
Thank you, Mr. Gaylord. Jesse Graston.
Good morning, gentlemen. My name is Jesse Graston. I live in Fort Lawn, South Carolina. To place justices of the Supreme Court as the ultimate arbiters of constitutional questions would be a very dangerous doctrine, placing us under the despotism of an oligarchy. I know they have with others the same passion for party, power, and the privileges of their force. The Constitution has elected no single tribunal. I know of no safe depository of the ultimate powers of society other than the people themselves. That was what Thomas Jefferson's opinion was on the constitutional question. And, I prefer to take his advice rather than Sotomayor or, Marshall or some of these other guys. even Roberts. I don't have to belabor so much. If we really look through Article 1, Section 8, we study it, we hold it up to the Affordable Care Act, I don't think we have to, it takes, the men in black to have to convince any of us that, Obamacare is completely, absolutely unconstitutional. So what we have on the menu today is two bills that want to deal with this. And to respect with Mr. Delaney's bill, H3101, it has some interesting ideas. Giving a tax credit, offset a federal penalty, involving directly the Attorney General to fight on our behalf. But after reading a little bit more into the language of the bill, some of the things concern me, and some of the ambiguities that are involved in it, where it says the Attorney General and protecting the harmed, who's to define what harm is? And maybe that's something we can discuss, flesh out a little bit more as to what considerable harm could be. If it's left up to a council of one, being the Attorney General, I'm afraid that I wouldn't want to place what my family's understanding or a friend's understanding what harm is, and just one guy's decision of what that could be. And so I suggest if we were to run with H3101, we start there. But I think we should also look at the fact that the Attorney General says in, I think, line 3, that if he was to intervene on our behalf, it says he may intervene. It should read shall, and not just giving him an option as to possibly intervene based upon his discretion. I believe it's already implicit in his job description that if he knows that there's been an unlawful act perpetrated against an individual, that it's his duty to intervene. So if we could adjust the language, instead of a bunch of words, instead of it saying may, let's put shall or must intervene. But also, after reading through the whole thing, I was a little upset just because I realized it presupposes that if we can stop the exchanges, that somehow we're not going to be affected, with the evils of Obamacare. And after studying, I haven't read the whole bill, but I've read enough to know that it goes for the tyranny, the evils that are in Obamacare far surpass just the exchanges. The implementation of it already has affected a number of people that I've talked to that have lost their jobs, their full-time jobs, down to part-time, because the employers are trying to avoid the mandate to buy them health care insurance. This is already destroying our economy. As they reference Section 2951, 4204, these are visitation agencies that want to inspect for the mental health of the parents and the children. Who is to decide what is mental health or mental illness? History records that the Soviet Union, they considered political dissidents as mentally ill. Is this the kind of power that we want to take the chance and one bill really goes after the whole juggernaut? And I take a little argument with the fact that it can't be defined. I mean, it can if we read through the 2,800 pages. I know that's a lot of work, and the 30,000 pages of regulations that we flesh out right now. But it is defined. It is the Patient Protection Affordable Care Act. But there's also one other amendment. If we were to go with your bill, we'd have to add also in the title, anyone that's trying to enforce the Patient Protection Affordable Care Act. We also have to add its counterpart, because Obamacare, the Leviathan, is two parts. It's the Patient Protection and Affordable Care Act, and as it was amended by the Healthcare Education and Reconciliation Act. If we're going to fight this in court, we're going to do this in the right way. We're going to have to fight it with specificity. And so we need to add whatever both bills, wherever we address the Patient Protection and Affordable Care Act, must add in there the other part. The Healthcare Education and Reconciliation Act actually contains some of the enforcement arms of Obamacare. So that's something we need to look at, and I would recommend doing so. But concerning H3101, I would also change a few things as far as adding in, we're in section 38-71-2120, after it reads the Patient Protection Affordable Care Act, insert, as it was amended by the Healthcare Education and Reconciliation Act. Also, the same in section 1 of section 38-71-2130. That's got to be in there. But when it comes to the penalties, aspect, I think if we want to modify anyone's behavior in society, what does the government do to us? They don't suggest that we don't rob a bank or slow down on the highways, that they attach a consequence to that sort of behavior. We have to determine, is this consequence, is this, whatever we're attaching to it, is it going to be worth the other side to actually put the brakes on what we're trying to do? It concerns me that, just a suggestion, if we are right in stopping and pushing back against unconstitutional federal tyranny, do we just want to suggest, or do we want to have some kind of enforcement power? So I would suggest that consequence could be debated. I'm totally open to seeing what we could come up with. Maybe it's a financial thing. Maybe we're going to withhold the federal income tax from these guys. Only appropriate the monies that are constitutional to the federal government. That might hurt. There's some other things we should get creative. I think we should table the bill and look at some of these options rather than just rushing forward with a quick judgment. But we need to have some kind of consequence. I suggest that they are uniform, whether it's state or federal agent for equal protection issues. But some of the assembly have told me that they say, if we do this, Jesse, this is going to lead to civil war. I suggest, and I submit to the committee today, the war has already begun. It's already begun. They have come after our personal liberties. There's an assault on our families, on our country, and our Bill of Rights. And I ask, when is it that I heard you, Mr. Pope, say, well, maybe that's when we'll arrest the federal agent. When they go after the guns or infanticide. Maybe then we'll, if we don't even know technically what's all in Obamacare, how do we not know that that's already ended? Section 1553 has some the verbiage and the legalese of that section. Can be interpreted in very different ways. Giving grant money to organizations that absolutely open up the door for eugenics in America. Is this something that we want to play around with? The rights of the people. I submit it's time to draw the line. We've been playing around for too long with federal tyranny. What employer in the right mind would tolerate an employee that comes to them and demands their servitude? I think I understand it's been a long time that we haven't had the precedent been set of states' rights. But at some point it's a slippery slope, and I'm just afraid the next step is, hey, it's legal. The Supreme Court said it's constitutional. We're going to relocate Christians and Jews to one part of town. Actually, we're going to get rid of the weak and the elderly. Maybe that's an Obamacare. Maybe it's not. But at some point, we have to decide. We have a moral high ground here. I think of Goliath. That he didn't stand a chance against a little shepherd boy because he was on the wrong team. God is with us. We have the moral constitutional high ground. And I just sense the grief of the cloud of witnesses today as I look around and I see that there's only 20 plus representatives that understand that he is with us. I'm asking for all of you to take a sober moment and think about the shoulders that we're standing on. Thomas Jefferson, James Madison. This is not like any other bill you've ever voted on. And I just really hope, as I bring my testimony to a close, I wanted to say, really take seriously this vote. I tell you right now, it's going to make you famous. It can make you famous in a number of different ways. But your legacies are being written. This is a watershed moment in American history. Your legacies are being written. How will your children remember me by? How will they remember me by? All of us. What do we do when we are faced with the tyranny of our day? And I'm asking all of you guys to consider the ramifications if we fail to stop this thing. And regardless of what our enemy's stature is, regardless of what they threaten us with, I say it's defense. It's time to play defense against federal tyranny. And I'll leave you with a quote from Federalist number 26, Alexander Hamilton, not being a real conservative at his day. But even him, he said, the state legislators who will always be not only vigilant, but suspicious and jealous guardians of the rights of the citizens against encroachments from the federal government will constantly have their attention awake to the conduct of the national rulers and will be ready enough, if anything improper appears, to sound the alarm to the people, and not only to be the voice, but if necessary, the arm of their discontent. Unfortunately, to some degree, the constituents are having to sound the alarm for you, but I'm asking that you guys interpose and be the arm of our discontent. Please protect our families with the powers that we've entrusted to you. If you don't, we'll find someone who will. Thank you.
I've asked the members of the subcommittee to let us power through till 2 o'clock, not take a break so that we can keep here and participate. But if you see members get up in. Not everybody's prepared to go this many hours without break. Mr. Adams.
I'm Britt Adams from Seneca, South Carolina. I'm glad you are taking the time. This is the most important issue in the state of South Carolina right now. We have a tyrannical government taking over our citizenships. When is the state of South Carolina going to stand up and do what you said in your oath to protect the rights of the citizens of South Carolina? Now, there's a lot of tools. I don't know which one's best. Nullification is one. 12 states are working to nullify Obamacare. Are you all talking with other states? Are you working with them? Are you figuring out how we can do this? There's a lot of great minds out there. We need to use them all. We got to think outside the box. 14 states are working to nullify the NDAA. 20 states are working to nullify federal gun laws. The word nullification being used in this country because by definition, the action of the state impeding or intending to prevent the operation and enforcement within its territory and law of the United States. That's what we're doing. We're trying to stop the government from impeding on our actions. I was here at a committee meeting yesterday, Ways and Means, and I was told, oh, this isn't about stopping Obamacare, this is about whether we're going to expand Medicaid rolls. That's what Obamacare is. Come on, guys, get on board. You know, y'all have got to wake up and smell the coffee. I'm not as good as everybody else, okay? I'm just a citizen. But you know what? I provide for my family, okay? I'm self-employed. I provide for my family. I know what it costs to pay for insurance. My insurance is up 30% because of this. Somebody's got to stand up and protect me. If it's not you, who? The other thing is, if you all stop this, look what it'll do for the economy of South Carolina. Talk about being heroes. You guys are going to be put up on a parade. We'll have doctors flocking here. Why? Because they can practice medicine, not like the doctor said back here, you know, without the government looking into it. You'll have business owners dying to come here. Why? Because they can actually make money without the government getting their little hands in there, you know? Some of this stuff's none of the government's business. They need to go away. You know, let's go back to where we used to live. And to finish with, you know, it's the choice of Obamacare. If it's implemented, then we can assume that the politician, the lobbyist won, and the rights and the freedoms of the citizens of South Carolina lost. Thank you very much. Any questions? Okay.
I think that was clear enough.
Good.
Thank you all so much for the opportunity to speak here for you all. It's a very distinguished occasion. I'm going to echo Jesse Grafson's remarks, as well as possibly some of his passion, hopefully, and as well as that of Britt. Before I begin, I just want to mention, you know, I'm not going to allege that H3101 is perfect. What I do wish to convince you all of today, and might get a little excited, so pardon me, I'm very passionate about this issue. But I do believe that the principles, the foundations of the two bills are very different. They're crucially distinguished. So let me then I have my prepared remarks. Honorable representatives of South Carolina, today this subcommittee faces one of the most important decisions of its tenure. That decision is whether to bow to pressure from above and sink under the waves of moral insignificance, or whether to submit to pressure from below and ride the tide of destiny. The ocean is the whole body of lawfulness, of right and wrong. The pressure from above is the influence of those who are afraid to stand, who would water down and minimize action for the nullification of those acts which threaten our families and our livelihoods. The pressure from beneath is the reality of this situation, spurred on by the rightful influence of popular opinion, a reality which necessitates a full and decisive action of nullification. Gentlemen, two acts are before you today. The first is a weak and powerless action, undergirded only by fear. The second is a bold and definitive solution, undergirded by 2 centuries of history, the opinion of our country's founders, the faith of our state, and the purpose to achieve a future for liberty. The first is H3473. The second, our bill, is H3101. I submit that the difference between these two bills could not be more stark. We fight for H3101 in opposition to H3473 because H3101 nullifies all of Obamacare. It is simply not intellectually or morally satisfying to state that to nullify Obamacare is to perform an act for which this legislature has no authority. Even if it is somehow not correct that we have no constitutional right to nullify, it is certainly not true. It is certainly true that we have the moral duty, for we shall each be judged one day at a higher court than that of the United States federal government. I'd like to deviate briefly from my prepared remarks here. Just list a few section numbers for the Obamacare bill on why this is a moral issue. That of behavioral health, 4001, 4. Transformation of communities, 4201. The individual wellness plan, 4206. And home visitations, so that a federal agent can knock on your family's door and inspect the mental welfare of you and your children, determine if it's a stress-free environment, and manage your disciplinary standards, is 2951. H3473 does not nullify any of Obamacare. It does not disallow any federal action. Even the provision regarding the healthcare exchanges applies only to our state government and its political subdivisions. The federal government, like a child with a temper tantrum whose parents have too long spared the rod, remains unrestrained. H3473 purports to set up a tax credit to offset the taxes taken by the federal government under Obamacare. This provision is laughable. There is no funding for such a tax credit in our already overinflated state budget. Where will the money come from? This provision exists only for political showmanship. It cannot and will not be implemented. H3473 states that the Attorney General may bring an action on behalf of the state for harm inflicted by Obamacare. This is already part of the Attorney General's job. The Attorney General already has the duty to bring an action on behalf of the state for harm inflicted on state citizens by the federal government. This is what resulted in NFIB v. Sebelius, in which the Supreme Court failed to strike down Obamacare. This provision is therefore pointless. Worse, this bill puts the Obamacare issue back into the hands of the court system and makes the state dependent on the courts to issue injunctions. Thus, if H3473 were passed, the entire nullification argument would be conceded. The solution is not to place the issue back into the hands of the courts, which have proved their incapacity and unwillingness to protect the American people. The solution is to follow the advice of the father of the Constitution, James Madison, and others, and resist the exercise of unconstitutional federal power. The solution is to nullify Obamacare. Gentlemen, the solution is H3101. And I'd be happy to answer any questions.
Thank you for coming. Next is Dr. John Cook.
Good afternoon. Thank you for the opportunity to be here. When I first came, I thought I was going to try to give you some nuts and bolts of ways that this Obamacare plan is already having negative effects on medical practices, and I can still do that if you'd like me to. But I really would like to tell you that I'm very proud to be in the company of patriots that have spoken already this morning. It'll be hard to top most of the things that have already been said. I did have some thoughts as I listened to some of the previous speakers, especially the law professors. In the last 15 to 20 years, American history and Southern history has become an avocation of mine. I'm a practicing physician in Aiken, South Carolina, so I'm not a lawyer, but this is an interest that I have. When I heard Professor Crocker this morning, the conclusion that you can only reach from what he said is in effect the only sovereignty allowed the only sovereignty the state of South Carolina has is that which is allowed by the federal government. Representative Delaney, you mentioned Appomattox and the outcome of the result of that. Basically, if we acquiesce to that totally, then we're simply saying might makes right. If we have no ability to resist or to stand up again, or to exercise basically a passive-aggressive type of resistance. You have mentioned the sanctuary cities and marijuana laws in several western states, and those are areas of nullification that are going on. Somebody mentioned that they thought Colorado and so forth wouldn't interfere with any federal enforcement, but I can tell you from reports I've listened to in fairly large detail on National Public Radio and Newsweek magazine that the state of Colorado is looking for a huge tax windfall in regulated marijuana sales. They're looking at whether big tobacco will take over the operation of the marijuana operations there, or whether other independent businessmen will set up these licensed marijuana shops. But they're planning on nullifying the federal government's drug law there, for sure. The previous physician who spoke mentioned something, war on doctors, and I think you can summarize part of what he was getting at there, in that we're being coerced to follow a more socialistic ideal rather than a Hippocratic ideal we were taught. When I graduated from medical school, we took a modified Hippocratic oath. It basically boils down to we will do the best treatment for each individual patient every single time we're with that individual patient. The socialistic model, which is now being followed more and more, and even by so-called managed care insurance companies, is the most good for the most people with the available resources. Well, of course, a lot of those resources skimmed off for the bureaucrats. But the Hippocratic ideal that is thwarted by the presence of that third party in our examining room with every single patient. Can they afford this? Will their insurance company allow this? Will their insurance approve this prescription or not? Inhibits us from being able to simply try to do the very best for that individual patient in that individual instance. And I think that's a large part of what was alluded to. I could talk to you some about some of the specifics, the electronic medical records, which is a mandate in the Obamacare. If any of you've been to your doctors lately, you probably noticed almost all of them either have converted or are converting to electronic medical record systems. Last year, I finally succumbed to that coercion and attempted to put an electronic medical record system in the office. It was an absolute disaster, administratively and economically. Could not be adapted to my practice or to my specialty. It's inordinately expensive. I'm basically going to face a loss of close to $50,000 as I now go back to traditional paper records so that I can tell why the patient was here, what I did at the time, and undo that damage. As an example of how that works, a year before that, one of the implementations, one of the manifestations of the Obamacare that was implemented was the requirement for electronic prescribing. If we were not doing, quote, meaningful use of electronic prescribing by June 30th of 2011, starting in 2012, we would be docked or penalized 1% on all of our Medicare reimbursements. So we took went to the effort to buy the software, get the training, learn how to do electronic prescribing, make sure that by June the 30th we had done the prerequisite number of electronic prescriptions plus a few more, so that we would not be penalized come January 2012. Guess what? Started being penalized. So then we found in some fine print and some of the myriad of updates that get sent every single day from Medicare to the office managers, if that electronic prescription was not associated with a separately identifiable office visit, it didn't count. In other words, if you came in and I took off your mold and you said, oh, by the way, doc, can you refill that athlete's foot medicine you gave me? And I said, sure, and we did it electronically, and I didn't bill you a separate office visit for the athlete's foot problem, didn't count. That's exactly the same kind of thing, and lots of docs are hoping that they're going to get stimulus money back as they get into electronic medical records, and that's the big carrot that's been held out to coerce us into electronic medical records, which in turn eventually will integrate all of your doctor's records with everybody else's records in the country. And, but there will be just as many catch-22s to prevent us from getting those dollars as well. As I already told you, it just was not workable in my office. I'm 65 years old now, so I just said I'll take the penalty. I wish I'd understood beforehand that I'd have been better off accepting their penalties than trying to invest in that system. If you'd like further information about electronic medical records, I can refer you to an editorial by Michelle Malkin on December 12th, and I've got some copies of that if you'd like them, detailing a lot of the problems with the electronic medical records a lot better than I can, and summarizing a lot of those problems. In short, to echo a lot of the previous speakers who talked about our constitutional rights and our history, I would just remind you of another really prominent South Carolinian named William Barrett Travis. He drew a line in the sand at a place called the Alamo. I'd ask you all to have the same backbone that he had and draw a line in the sand for us. Thank you.
Thank you, Dr. Cook. Next we have Mr. Robert Slip.
I certainly want to thank Chairman Bannister and Chaplain Chairman Delaney for allowing me to speak to you all very briefly this morning. I want to say that I favor Obamacare H3101. Nullify Obamacare in South Carolina. It is not working. It's not going to work. We've been told time and time again that the United States was formed by 13 states who came up with a constitution by which the federal government would govern the states. But it limited the federal government to only certain items. All other government was reserved to the states and the people respectively. Health care is not mentioned in the Constitution, and as a result, it must belong to the states and some of the local subdivisions of the states. So, what will it do? It will force all Americans to buy health insurance, which is another thing that is completely unconstitutional. And as the doctors mentioned, there are many wealthy Americans who do not choose to buy health care for themselves. What else will it do? It's going to kill jobs and small businesses by the millions in the process of giving Americans a kind of health care that will be far, far inferior to that which we have been used to receiving. And we owe it to our citizens to protect their health care. I'm going to suggest if y'all take this courageous stand and pass H3101, it just may be that the federal government is not going to come after you immediately with all sorts of judges and tax collectors may make them think twice that perhaps they are going too far. So, South Carolina has an obligation to protect the health care of all South Carolinians by nullifying this bill. One final thought. Many other things are going to come up. Guns. Whether or not chaplains in the military, I'm a retired Army chaplain, and I'm 82 until about 5 years ago I was an active pastor. We've lost 63 chaplains in the military today because there was a change in government policy and they were suddenly told that they could not say to their parishioners that the Bible was the inerrant Word of God, or that the Lord Jesus Christ was the only one who could save them. And that's not in public places, but to their own military congregations. And so, 63 resigned their commissions. The alternative was being court-martialed and serving time in prison. And one has done that. So, this is a good place to start. Going back to both our Constitution in South Carolina and the United States Constitution. And then, when these other issues that have been mentioned come up, perhaps the federal government will back away and begin to, again, do only that which is unconstitutional. So, please do your duty. Edmund Burke said, all that is necessary for the triumph of evil is for good men to do nothing. I know y'all are good men. And 14 other states are about to do the same thing, or seriously considering it, that y'all are. So go ahead with them. Do what is right. Look to God. And you will have done the right thing. Thank you.
Thank you, Mr. Slint. Next on the list, Steve Lefemin.
Mr. Chairman, Steve Lefemin from Lexington County, I'm the Director of Columbia Christians for Life. There's one short, Mr. Smith, I'll be glad to provide you one later, Mr. Delaney. I'd like to begin by speaking in regard to federal laws and Supreme Court decisions. I make two statements. Number one, federal laws are not always the supreme law of the land. And number two, Supreme Court decisions are never the supreme law of the land. I refer to the handout I just gave you, Article 6, which is from Clause 2, the first part of that. And I'll echo what's been said before. The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. The Constitution itself, the written document, the written covenant for the country, says there are three things that are the supreme law of the land. The Constitution itself, the written Constitution. Federal laws made in pursuance thereof, and all treaties. To quote an online source that covered the topic of the Supremacy Clause, quote, the Supremacy Clause only applies if Congress is acting in pursuit of its constitutionally authorized powers. Federal laws are valid and are supreme so long as those laws were adopted in pursuance of, that is consistent with, the Constitution. I don't see anywhere in Article 1, Section 8, where the federal government, where the House can pass, the Senate can pass, and the President can sign a federal law requiring an individual mandate that has a penalty to it, forcing Americans to buy insurance. I believe Marbury versus Madison, the 1803 Supreme Court decision, has been cited before by one or more previous speakers. One of the quotes from that decision is, "All laws which are repugnant to the Constitution are null and void." Obamacare was effective March 23rd, 2010. I would assert that it was null and void on March 23rd, 2010. Another issue that's been raised is the issue of the oath, and I appreciate that members take the oath seriously to support and defend the Constitution of the U.S. Constitution as well as the state Constitution. Article 6 of the U.S. Constitution says, to continue the remainder of that clause, Clause 2 from Article 6, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. I would assert that for a member to uphold his oath of office, to uphold the U.S. Constitution, that he would not recognize Obamacare as the law of the land. Because the Constitution says that the second thing that makes up the law of the land are laws of the United States, which shall be made in pursuance thereof. Obamacare is not made in pursuance of the U.S. Constitution in Article 1, Section 8. It is not not within the enumerated delegated powers of Congress to pass such a law. So my exhortation to you all would be to uphold your oath, yes, and do not recognize Obamacare as the law of the land because it is not in the Constitution. And the second point about Supreme Court decisions, this certainly runs contrary to what law students have been taught for the last century, including over at USC since the early 1900s. If you look on the wall of the lobby in the USC Law School, at one time in that school in 1876 or thereabouts, Blackstone's commentaries on the laws of England formed the basis for the curriculum. And Blackstone affirmed that God's law, God's revealed law and natural law, rightly formed the basis for man's law. In the early 1900s, the curriculum at USC Law School was changed, and it was changed to the case law system. That's on the wall of the lobby at the USC Law Center. If you ever like to go see, it's a very interesting accounting of the history of the law school. But again, going back to Article 6, just a plain reading. I'm not an attorney. Just a plain reading of Article 6 says there's three things: the Constitution, the laws of the United States made in pursuance of, and treaties that are the supreme law of the land. Noticeably absent, as it says on the handout, noticeably absent from this list in Article 6 of what the U.S. Constitution itself says is, quote, the supreme law of the land, are U.S. Supreme Court decisions. They are not the supreme law of the land. Now, obviously, there was a challenge to Obamacare. The Supreme Court granted cert, heard oral arguments, and there's a decision rendered on June 28, 2012, ostensibly saying Obamacare was legal. And many have questioned what happened with Chief Justice John Roberts. All that topic notwithstanding, that decision is not the supreme law of the land. It is binding on the parties of the case as to the particulars of the case, including the facts, the parties, and the law. But there's it's not in Article 6 of the Constitution itself to say that the Supreme Court decisions are the law of the land. One speaker has already referenced a quote from Thomas Jefferson, so I'll pass on that. But Andrew Jackson said in his veto message to the rechartering of the Bank of the United States on July 10, 1832, quote, he said, "It is maintained by the advocates of the bank that its constitutionality and all its features ought to be considered as settled by precedent and by the decision of the Supreme Court. To this conclusion, I cannot assent. This is President Andrew Jackson. He went on, and then to pick it up again, he said, the Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. Each public officer, and I would say this applies not only to the three co-equal branches of the federal government, this also applies to every man, every officer that takes an oath of office in the country to uphold the Constitution. When Jackson says each public officer who takes an oath to support the Constitution swears that he will support it as he understands it and not as it is understood by others. It is as much the duty of the House of Representatives, of the Senate, and of the President to decide upon the constitutionality of any bill or resolution which may be presented to them for passage or approval, as it is of the Supreme Judges when it may be brought before them for judicial decision. The opinion of the judges has no more authority over Congress than the opinion of Congress has over the judges. And on that point, the President is independent of both. The authority of the Supreme Court must not, therefore, be permitted to control the Congress or the executive when acting in their legislative capacities, but have only such influence as the force of their reasoning may deserve. He's talking about the three co-equal branches of the federal government. In this discussion concerning notification and concerning how we view whether the Obamacare Act, effectively we're going into law March 23rd, 2010, is constitutional or not, I would ask you to assert your right as men who have taken an oath to uphold the Constitution, to make your determination. Is Obamacare within Article 1, Section 8 of the Constitution? Is Obamacare constitutional? And if you in your heart of hearts and with your training believe it is not, then I would say you have a duty to uphold your oath as you understand the nature of Obamacare to be, i.e. unconstitutional. I conclude with, I can step back for a moment and look. This is one issue, and we are coming under increasing tyranny in our land. And whether it's the gun control issue, or Obamacare, or we've already killed 55 million children in the womb, or on and on and on. We've seen the First Amendment, the Second Amendment, Fourth Amendment under attack. I would say from a spiritual standpoint, and perhaps even not all Christians will even share this view, but in my reading of Scripture, I would say this nation is under the judgment of God. Some people talk about the judgment of God as being some future calamitous event. I believe it's incremental, progressive, continual, and God sends his signs, his messages, and his messengers of warning that we would turn back to him. I'm a pro-life missionary, and I direct a Christian pro-life, pro-chastity ministry. And I believe our greatest sin is our turning from the Lord Jesus Christ and his law. We rejected. God is the one who ordains civil government. He's the one who has ordained the family. Civil government gets its authority from God. But I believe our greatest moral crime, under the second table of the Six Commandments, is our shedding of innocent blood. And if you study the shedding of innocent blood in Scripture, that is something that can cause the destruction of nations. And I'll share one passage, and I will conclude with this. From Psalm 106, it's talking about the children of Israel, the ancient nation of Israel committing child sacrifice, and how the Lord reacted to it. Beginning in verse 37, yea, they sacrificed their sons and their daughters unto devils, and shed innocent blood, even the blood of their sons and of their daughters, whom they sacrificed unto the idols of Canaan. And the land was polluted with blood. Sounds like America. Thus were they defiled with their own words, and were whoring with their own inventions. Therefore was the wrath of the Lord kindled against his people, insomuch that he abhorred his own inheritance. And he, talking about the Lord, talking about God, he gave them into the hand of the heathen, and they that hated them ruled over them. Their enemies also oppressed them, and they were brought into subjection under their hand. Many times did he deliver them, but they provoked him with their counsel, and were brought low for their iniquity. Nevertheless, he regarded their affliction when he heard their cry. I believe that God will hear our cry if we will cry to him and turn from our wicked ways, that he might bring healing in our land. Thank you.
Thank you, Steve. We're running very short on time. The House convenes at 2 o'clock, and by rule, we have to be over there. There are a lot of people signed up on this list who we have not gotten to and not had an opportunity to speak, which will require us to come back and convene another subcommittee hearing to hear from you guys. Obviously, we'll take additional people to sign up at that time, but because of the hour and the fact that we're getting ready to start, we'll have to be adjourned for the day. I want to thank all y'all for coming down and maintaining your composure, even though this is a very serious issue, and I appreciate all the comments so far. I look forward to hearing from y'all at our next meeting. Thank you.